मॉर्निंग मैम।
गुड मॉर्निंग सिद्धिका।
एक गुड मॉर्निंग। मैं एक्चुअली व्हाट्सएप में सबको मैसेज भेज रही थी कि सिद्धिका को को होस्ट बनना देना।
हाँ वही कर रहे मैम।
हाँ हाँ।
आकाश सर हेलो।
हेलो सुना आप आकाश और प्रतिभा, मैंने देख अपने कॉलेज का ग्रुप में वो डाला है लिंक, बराबर है ना? यूट्यूब वाला लिंक। हेलो हेलो चालू करी तो सिद्धिका सिद्धिका
हाँ मैम, हाँ मैम।
वो शेयर करते ना, वो जो हमने वेलकम वाला डालने का।
हाँ हाँ मैम, कर रहे हैं। निर्मल का वेट कर रहे हैं। आ
तो
रहा है।
फोन कर, हाँ
Good morning, Selvi Madam, and good morning, students.
Good morning, sir.
Good morning,
Good morning, sir.
everybody.
Sir, we'll wait for 5 more minutes. The guest will be joining at 10 o'clock.
Sure, Madam. Sure, I'm around. Thank you, ma'am.
Selvi, I have already joined. Huh?
Yes, ma'am. Good morning, ma'am.
Good morning, Madam.
Good morning, Himanshu sir. Good morning.
Parvez sir has joined us.
Good morning, everybody. This is Parvez Kudroli here.
Siddhika.
Good morning, sir.
Good
Welcome
morning.
to Junjunwala College.
Thank you.
Good morning.
Thank you,
Welcome.
ma'am. Good morning.
Parvez sir, we have our director, madam, Usha madam, and our principal sir, Himanshu sir also, who have joined us.
Good morning, Usha ma'am, and Principal
Himanshu
sir
sir.
also. Himanshu sir
Good
also.
morning. Good morning. Welcome. Welcome.
Thank you so much. Thank you for having me on this session and giving me the opportunity to conduct this session on
Siddhika,
IPR.
Yes,
In fact,
yes.
it's a pleasure, sir, to have you this morning.
Thank you.
Siddhika, I think we can start.
Okay, ma'am. Hello and welcome to all the dignitaries. Mr. Parvez Kudroli, Mr. Saurav Jain, Principal Dr. Himanshu Davda, Director Usha Mukundan ma'am, fraternity and students of RJ College. We wish you all a very good morning. On behalf of Ram Niranjan Jhunjhunwala College, we are delighted to welcome all of you for the workshop on entrepreneurship and intellectual property rights. Let us welcome the man who needs no introduction and as known among us as for his wisdom and his knowledge. Our Honorable Principal Dr. Himanshu Davda sir, I would like to request our principal to present his welcome address.
Thank you and good morning, everyone. Respected guest speaker for today's morning, Mr. Parvez Kudroli, Principal Associate, Khurana and Khurana. Mr. Saurabh Jain, founder of Fun to Do. Dr. Usha Mukundan Madam, former principal and now the Director of Academics at Hindi Vidya Prachar Samiti, the governing body of our college. Ms. Selvi Nadar, coordinator for the BMS program. My teacher colleagues from BMS department and other departments. My dear students of BMS and also the students from postgraduate section of other disciplines of science who have joined today morning. I extend a very warm welcome to each one of you to this morning online workshop on entrepreneurship and intellectual property rights being jointly organized by the BMS department and Ram Niranjan Jhunjhunwala College Innovation and Incubation Cell. Well, friends, change is the only constant thing. And in this new millennium, the higher education in Indian universities and colleges is also getting a facelift. Boundaries between different disciplines of science are dissolving, and a small classroom in a college is extending to a global classroom. Education without research, research without innovation, innovation without creation of an opportunity, and an opportunity without challenges will make us all fall flat in this process of evolution. While research tests our knowledge, the innovation gives it an authentication, but not only that, also gives it an application. It is this application that creates opportunity. And dear students, you should always remain prepared to grab this opportunity to do something good for yourself and globally to the human race. At RJ College, we keep taking small steps towards making our students independent professionals. And today's morning is one such step towards the same. Mr. Parvez and Mr. Saurav, I extend a very warm welcome to you all for spending your time interacting with our students. And we are eager to hear you both. Thank you, Salvi Madam, for organizing this event. Thank you, Usha Madam, for being at the realm of the activities, guiding us. And dear students, this is an opportunity to get the direction in making your dreams turn into reality. Thank you, everyone, for being present here. And I welcome you all on behalf of Jhunjhunwala College. Thank you, everybody.
Thank you so much, sir, for always being so supportive. Now, I would like to invite the one who gives the best advice to every student in the college. She has been a guiding light since day one and always encouraged students to give their best. All of us look up to her. Calling Usha Mukundan ma'am for director's welcome address.
Ma'am, you have muted.
Good morning, everyone. Welcome to Jhunjhunwala College. Mr. Parvez and Mr. Saurav Jain, who have joined us today morning to enable our students and all of us find a happy place to conquer the despair which is existing due to the pandemic. Our smiling principal, Dr. Himanshu Davda, the coordinator of the BMS department, always innovating, trying to do the best for the students, Selvi Nadar, Vice Principal Captain Praveen Nayak, teacher colleagues from various departments, Professor Vilasni Patkar, and all my very dear students. We often say that the one thing which is in our mind is to find a job. And we always think the job is going to give us the required satisfaction, contentment, and a security for our family. These two youngsters, I think, are going to give a different direction to enable you to become a job provider rather than a job seeker. And further, whatever innovations you make, whether you have done research or a new brilliant idea, how to ensure that lifelong you will reap the benefits through protecting your intellectual property. And that is what the other speaker is going to tell us about. Pandemic has also made education available anywhere, anytime. And this is, I think, when you look at the positive side, one avenue which has opened, that is a blended teaching. You can learn with the click of a mouse, sitting at the comfort of your residence. But having said that, we miss the personal touch. We all teachers miss the chirping of the students in the campus, the interactions that we have with you all. And I'm very sure very soon you all will be back in the premises, and our very own guest will also be available to us in person for greater interaction. With these words, I extend a very warm welcome to each one of you. I'm also looking forward to listening to the new direction that our youngsters are going to give us, and welcome to all of you. Have a gala time, enjoy learning, enjoy interacting with each other. Thank you very much, Selvi, for arranging this workshop.
Thank you,
Thanks.
ma'am. Thank you.
Thank you so much, ma'am.
Entrepreneurship has been regarded as the adaptation of various industries in various innovations in industry. It is the quality of developing resources of the institution, developing human capacity, performing creative activities, and coordinating new thoughts. Entrepreneurship is that economic component that organizes and coordinates various of product sources of production. It is not only to adopt new works and behavior, but it is also the transformation of personality and to establish a new identity through that. And intellectual property rights allows these innovative entrepreneurs to protect their inventions, to protect their technology, brand name, design, and creativity behind the concept. So, to broaden our knowledge on this concept, let's begin our today's workshop on entrepreneurship and intellectual property. Now, I would like to call Siddhika to introduce our first speaker for today, Parvez Kudroli.
Thank you so much, Gauri. Parvez Kudroli is a software inventor, patentee, and entrepreneur, and has obtained patents for his invention in India and USA. He has experience of developing and inventing software, drafting and prosecuting patents, patent searching, conducting patent workshops, commercializing patent rights, and managing a software IPR related startup company. He is also registered patent agent admitted to practice before the Indian Patent Office. His focus at Khurana and Khurana is on consultancy, business development, and client relationships relating to IPR strategies, patent, trademark, copyright, and design. He has conducted intellectual property awareness sessions, IPR training programs, and patent drafting workshops for many organizations and institutes. So let us welcome our first speaker for today, Mr. Parvez Kudroli.
Thank you, Siddhika ma'am. Good morning to everybody and welcome to this session on an introduction to intellectual property rights and especially focusing on patents. Thank you very much. I would also like to thank the management and the college, Ram Niranjan Jhunjhunwala College and all the entities, Usha ma'am, Himanshu sir, Selvi ma'am, everybody for giving this opportunity and also bringing before the students this very important topic of intellectual property rights and especially patents. This is very important in the context of we have students and this session today, the two sessions today are focused on are looking at this whole idea of entrepreneurship for all the students and others attending this webinar or online session today. The background, the context for this is the potential for entrepreneurship. Now, as has already been highlighted by Usha ma'am and Himanshu sir, entrepreneurship means you would have to be very serious about protecting your intellectual property through intellectual property rights. You really can't have in this day and age and entrepreneurship and entrepreneurship based venture without thinking of protecting your intellectual property rights, because the time where one could manage running a business or having doing entrepreneurship based on physical goods and trading of that or just manufacturing without looking at the IPR part, those days are coming to an end. A lot of things are based completely on intellectual property, which means ideas, thoughts, concepts, things which are created from somebody's mind, and that mental creation, that intellectual creation itself has value and therefore needs protection. And it needs protection not just because it has value, but for it to be economically available to the people out there with a sound economic footing so that it's viable, it's economically viable. You need to have protection on that intellectual property that you might be creating. Okay. And when we talk about entrepreneurship, especially for students, we can guess, we can imagine mostly these will be small ventures, newly starting up startup ventures, right? What assets would a startup be having? The main asset that these startups would be having would be the people who are working on this, who are starting this and working on this, and the thoughts, the ideas, the intellectual property that they come up with. Startups, at least to begin with, will not be having a lot of resources. They'll not have a lot of money, they'll not have big facilities or factories to begin with. The main thing they have is an idea, a thought, a concept, and that urge to take this out there to the wider world on a sound economic footing. So whatever idea they start with, the intellectual property they start with, and then create on an ongoing basis, it's very, very important that they have a good strategy. Firstly, awareness about IPR and a good strategy to protect it, safeguard it, and take commercial advantage out of that IPR. So that's the context for the session that we have today. Okay. With this, I will get into the actual session. I'll just share my screen and start the presentation. If somebody has a question, most likely it might be considering the limited time. I think we need to complete my session by about 11:30 today, about an hour and 15 minutes. And if people have questions, mostly I would think that the end of the session, maybe 5-10 minutes, we can have a question and answer at that time. Nonetheless, if somebody has a burning question, they have a real, thought which is distracting them from being present in the session and they'd like to ask it immediately, they can very well, unmute themselves and ask that question. But at the end, I hope to have a question answer session for this thing. Okay. Now, let me just share the screen and start my presentation. Okay. Can you see my screen? Is it visible now?
Yes, sir.
Yes, sir.
Okay. Yeah. So, as is mentioned on the screen, today's session is an introduction to intellectual property rights. Uh, we will start with an introduction to the four main types of intellectual property rights, that's trademarks, copyrights, patents, and industrial designs. And then we'll focus specifically on patents. Okay, what are the important aspects about patents? A little bit about, in that context, you obviously have to talk about what's an invention. And we will complete the session with a case study or an example of somebody who had come up with some invention, and then later on what happened with that, how did it come out to market, or what did they do with that. So this is what we'll be covering in the session today. Let's go to the first slide. Main four intellectual property right types. Okay? Now, there are not just four intellectual property right types, as you see on the screen. There are more than four. There are many types. Apart from patents, designs, trademarks, copyrights, there are other types of intellectual property rights, like, for example, geographical indications, trade secrets, semiconductor circuit design, plant varieties protection. There are and copyrights and related rights related to copyrights. So many other types of intellectual property rights. But these four main types of intellectual property rights you see on the screen, and on which we'll be discussing today, are the ones that we come across the most. Okay? So we will, considering we have limited time today, these are the most commonly used, or the ones that we interact and deal with the most. We'll be focusing on these four intellectual property right types. Okay? Now, uh, on the screen you see there are four intellectual property rights mentioned, and on the left side, and on the right side are the intellectual property, the underlying work difference between intellectual property, having or creating an intellectual, getting an idea or a thought in your mind. Just you get some idea or a thought in your mind, you create some intellectual property. When you get that idea, you think about it, you work something out, you have clarity on it, you are actually creating intellectual property. That's in your mind. Maybe after that you'll document it on a piece of paper, okay, or in on some medium. Okay, at that point you have got the intellectual property idea, you have created it in your mind, you've also documented it, but get there, have any right on that intellectual property. Okay, because you've just created the intellectual property, you got the idea, and then you have documented it. You haven't protected it, you haven't protected it from being copied or misused by others. Just creating intellectual property and documenting it is not enough. It is susceptible to being copied, misused by other people. That's where the concept of right comes in. Not just you create an intellectual property which might have a lot of value and it might be useful for a lot of people, thousands or lakhs of people out there, right? You have to take act a right on that intellectual property in your name or in the name of your organization. Okay? Then you can control who else can use it or not use it. Till then, you can't control what others can do with that intellectual property. They are free to use, copy, misuse, take advantage, and you might not get any benefit. You might not be able to use it yourself. Okay? So until you get that right, or you take steps, you take action to secure your rights, you're in a difficult situation. You're in an unprotected develop this intellectual property into a product which can be produced and distributed and sold and consumed in the market. Because the moment you invest in doing this, or your team or your organization invests in this, and suppose it fails in the market, nobody will bother about it. But if that intellectual property based product or service or something you uh, develop, you produce, you distribute, and it's a success in the market, a lot of people are taking advantage or using it or benefiting it, then all the other people or the organizations, people, teams, and companies will start noticing that. They'll see there is some intellectual property based product or service which has been developed, launched, distributed in the market, and it's a success. Now, these people have invested in creating, developing, distributing, launching, and making it a success. Now it's our turn to take advantage of those people's time, effort, and money put in. Now we will actually exploit it. We will launch a similar product or service in the market. We will copy their intellectual property and make a lot of money. And if that organization copying it is a big company with a lot of resources, they will actually develop and launch a similar product or service in the market within 1 or 2 or a few months. And the entity or the person or the team of people who actually developed this intellectual property and made it and launched it in the market, they might have initial maybe a month or 2 or 3 months of selling it and making some money out of it. After that, the big competitor takes over the market. They are copying your intellectual property. Invested in copying after it was hello. Can you
Hello.
hear me? I think we got disconnected for a moment.
Yes, sir. So, but then a voice is also breaking in between.
Okay, can you hear me now?
Now, yes, sir. Now it's audible.
Okay, right. Okay, just let me share again. Selvi ma'am,
Yes, sir.
is the slide visible now? Is
Yes,
everybody
sir.
able to see and
Yes,
hear
sir.
me?
Yes, sir.
Hello?
Yes, sir. The screen is visible and you're audible also.
Okay, okay, right. Okay. If you don't mind, I'll just also have a little bit of my tea. So we were discussing about a scenario where somebody creates some intellectual property, and we look at what exactly are these intellectual properties, and somebody else is exploiting it once it's developed and proved that it's a successful thing which there's a lot of demand for in the market. Somebody else exploits it. Now we want to prevent this. Doesn't make sense. Not just is it unfair, economically it doesn't encourage more creation of intellectual property and entrepreneurship, because somebody puts the time, effort, and money in creating, developing, launching, distributing some intellectual property based product or service, and somebody else copies and takes advantage and gets the benefit. The people, the organization which invested in creating is gets very little in terms of returns. Economically, this doesn't work. That entity won't survive, or even if they survive, they'll not be in the intellectual property creation, innovation business anymore, because they see we had innovated, we had created intellectual property, we launched it, we made it a success, but somebody else took advantage and got the benefit. That doesn't work. That's why not just it's important to create intellectual property, but critically important for it to be protected, that intellectual property that you create to be protected through an intellectual property right. Okay, understand the difference between intellectual property that you create in your mind and you might document it or express it in some form, and taking active steps to get an intellectual property right, the corresponding correct type of intellectual property right on that intellectual property, and thereby protecting your intellectual property. Okay, very, very important. Now, as I mentioned earlier, on the right side of the screen are the various types of intellectual properties that you might create. And on the left side of the screen are the intellectual property right, the right that you can get on the intellectual property that you create. Okay. The reason why I'm emphasizing is this aspect is you might create a certain type of intellectual property which originates in the nature of an idea, a thought, a concept, a mental creation. It's intangible in one way. Okay, the idea itself, the intellectual property itself is just in the nature of a concept, idea, intangible thing which you can't hold in your hand. Even though intellectual property rights are property rights, they are intangible properties. Okay, unlike a tangible property, for example, like a piece of land that you own, that or a house that you own, or a device like a mobile phone. This is a property that you own, right? Now this is a tangible property you can hold in your hand. If you have a house, you can sit inside your house. If you have a plot of land, you can stand on that plot of land. If you have a bike, you can sit on that bike. These are tangible properties. Intellectual property is intangible, you can't hold it. And other problem with it is these ideas are very easy to be copied. Once you get the idea documented, for the other person to copy that idea is the easiest thing to do. It can be easily replicated at zero cost. This is a big problem for intellectual property creators. How do they protect their intellectual property through an intellectual property right and ensure that others don't copy without permission and take undue advantage and misuse and eat away your market on the intellectual property? We have the various types of intellectual property rights, intellectual property that we create. And on the left side is the type of intellectual property right that you should apply for, or the correct type of right. Now we'll quickly go through these four intellectual property types and the corresponding suitable intellectual property rights. As well as after this slide, there are examples which will further clarify the concept of if you create a certain
Hello, sir.
know about it, nobody will give you credit.
Sir, you're not audible.
Is the volume low or is my voice breaking?
So no, we are not audible also. In between, na?
Huh?
There's
Completely
no
the voice is breaking.
Yes,
Just
sir.
1 second, just let me check on this. I don't know why we have a problem with this. What I'll do is I'll log out and log in through my Wi-Fi hotspot on my mobile phone, if you would permit.
Yes, sir. Yes,
Let
sir.
me just do that because I have a Wi-Fi connection. I don't know why we are having problems on this. Okay. So
Sir, no
just let
problem.
me
Yes,
do
sir.
that. Okay. Okay, can you see me now? Am I logged in?
Yes, sir. Yes, sir.
And can you hear me clear?
Yes, sir.
Yeah, I would request everybody, whoever can, to mute themselves and also switch off their video to ensure better, connectivity. Okay, let me share my screen again. Okay, I hope the slide is visible. Let me continue. Sorry for the disturbance. Okay, and let me know in case there's a problem with the audio again. Okay?
Yes, sir.
Yeah. So if somebody creates a technological invention, which means a new product or process, an innovative product or process, or a part of a product or process, I mean there is an existing product, you improve one part of it, or there is an existing process or a methodology for making something or doing something, you don't create a totally new process, you improve that process so that some problem associated with the existing process is solved, and technologically the process works better and gives better results. So when somebody comes up with a technological invention, the type of intellectual property right that you file for would be a patent. If you come with a technological invention, don't prepare a written document for that and file a copyright application. That's useless. It's a waste of time and energy. And more dangerously, it gives you a false sense of your intellectual property being protected. You might for create an idea for a technological invention, you'll describe what the invention is, what are the parts, how it works, what are the advantages, benefits, etc. Make drawings of the product or the flowchart of the process, etc. Everything you document on paper. And then if you go and apply and obtain a copyright, complete waste. Actually the idea itself is not protected, only the document gets registered as a copyright. Okay, which means the idea is open for somebody to implement and copy in their own products without any protection. So a copyright is not the right type of protection for a technological invention idea for an improved product or process. If you come up with a new product or process which is new, innovative, and useful, the type of intellectual property right that you apply for would be a patent. Now, what are examples of a technological invention? Suppose you come up with an improved display for your mobile phone, okay, which is giving double the resolution on the screen compared to existing screens. So the resolution on the new display of the mobile phone is double. You have created a new display. Okay, or rather an improved display which gives double resolution. Now that's a technological innovation. It's an invention. It's an improved product, a part of a product. Therefore, you can apply for a patent not for the mobile phone, but for, and not even for a mobile phone display, because mobile phones and mobile phone displays, millions of those already exist. Everybody knows about that. What you will file a patent for would be the improved display which gives double the resolution, and you'll describe the physical parts or the new process that you have used in making that improved display, or the new materials or the new part that you have added into that display to make it double the resolution of existing displays. This is what a technological invention looks like. And you saw that it could be you have come up with the improved process for making the display which gives double the resolution, or you might have added a new part or a new material when you're making that display, which means a product invention or a part of a product invention, which is what you would be patenting, either a product or process or an improvement to a product or a process. This is what a technological invention looks like. Similarly, there could be an example such as if you improve the light that you're using in your house, or you come up with an idea to improve air conditioners, or you come up with an idea to improve car engines, or you come up with an improved medicine for treating, for example, heart disease. And there are already medicines for treating heart disease. There are already composition known for treating heart disease, but you come up with an improved composition, maybe using a new process or maybe adding a new ingredient, which leads to a scenario where there are less adverse side effects when somebody takes that medicine for heart disease. Because what happens very often with medicines is somebody comes up with some medicine for treating one disease, for example, heart disease, that causes other side effects. So that person, when they are taking that medication for heart disease, the medication helps with the heart disease but causes problems with their lungs. Okay, now you don't want those kind of side effects, right? That's why people do a lot of clinical trials, etc. But nonetheless, all medicines, all compositions have some or the other side effect, at least to some extent. Okay, now if somebody comes up with the improved medicine, for example, for heart disease, which has less side effects, is that not a great invention, a technological advancement which provides very real benefits to the users of that medicine? So such things can be patented. The new composition or the new process for making that medicine for heart disease, which has doing the same function, treating heart disease, but it has less side effect, that can be patented. So this is what an invention, these are how inventions look. It could be a medicine, it could be a method for making medicine, it could be a bicycle, it could be a car, it could be an engine, it could be a mobile phone, it could be a bed or a chair or anything. These kind of physical products or processes, these are technical inventions. The intellectual property is an invention, and the right that you apply for this intellectual property is a patent. Okay, let's look at the next item. The intellectual property right that you see on the left side is a registration as a industrial design. And what is an industrial design registration obtained for? What is the intellectual property for which you should apply for industrial design registration? That is an aesthetic design applied to an industrial product. Now, what is an industrial product? Again, the same thing. Mobile is an industrial product. The laptop that I'm using is an industrial product. A car is an industrial product. A medical composition, no, that's not, because the looks don't matter really there. It's not relevant for industrial design. A fan, a light, a car, a chair, a table, these are physical products. These are all industrial products. Anything that we use, anything of use in industry or personally by us, these are industrial products. Now, industrial products generally are created for their functionality. For example, I have this mobile not just, because it's a slab of, glass and plastic and, processes, etc. I have this with me. I use this because it has some functional benefit. I can make, send, and receive calls using this. I can access the internet. So there is a functional benefit to this. Okay. Apart from the fact that this product has a functional benefit, there are various ways of physically designing it or giving it a shape. such that it looks good or aesthetic. Okay, so the functionality of this phone will be protected through a patent registration if you improve the working, the functionality of this phone. However, the appearance, the shape, the design of this phone can be protected through industrial design registration. Industrial design registrations are meant to protect the appearance, the shape, the aesthetics of an industrial product, some new design that you apply to an industrial product. That's what it's meant to protect. So when you design a new product, you create a new design for a product. If that new design results in an improved working of the product, then you should file a patent, because patents are meant for technological inventions which have some functional benefits, some technology advancement. Industrial design registrations are meant for those new designs which functionally work the same as the old. They have no functional benefit, no working benefit, but the designs merely look good. Okay, now why is it important for things to look good? Let's take the example, for example, of a child going to a stationery shop. A parent takes a child to a stationery shop to buy a pencil box. Now, when that child is at the stationery shop, the owner of the shop keeps two different pencil boxes in front of the child. One is a plain rectangular pencil box in which you can keep your pens, pencils, rubber, sharpener, ruler, etc. And the other box that the shopkeeper keeps in front of the child, the stationery shop owner, is a pencil box shaped like a BST bus. Very nice looking, with door, window, the steering wheel visible, the driver sitting there, the wheels, etc. Everything. It's like shaped like a pencil box. Now, if you look at the functionality of both the pencil boxes, both are meant designed. What they do is they will hold your pens, pencils, rubber, sharpener, ruler, compass, etc. That's the working. So both work the same way. But guess which pencil box the child is more likely to be attracted to and more likely to buy or tell the parent to buy? Most cases, the child will opt for the box which is designed like a bus. It's shaped like a bus. It looks like a bus. Now, by buying the pencil box which looks like a bus, the child doesn't get any functional benefit, but the child does get an emotional benefit of looking at a more attractive pencil box every time he or she is using that pencil box. And people, human beings, being emotional beings, have a lot of value, not just for functional products, but products which also look good. Looking good in itself has value for human beings, because human beings are emotional beings. Okay, I'm suppose I buy a car, okay, because I want to travel in the car and take my family out or friends out and all that. Now, given a choice between a car which is boxy shaped and not good looking, not aesthetic, plain kind of design of the car, okay, and a similar car doing the same function but which is more aerodynamically designed, looks more aesthetic, more attractive shape, guess which car I'm more likely to buy? And this concept applies to all products. It could be a laptop I buy, mobile, car, pencil box, school bag, any product, a chair, a table. It could be anything. I've even seen even people who make these petrol pumps which are used at the petrol pumps. There's a box from which the petrol comes out. Designers give aesthetic shapes even to that petrol pump. What's the function of that petrol pump? To pump out and dispense petrol, right? That's what it's supposed to do. But to attract customers to come to that petrol pump, the petrol pump owners look out for who can provide me a better looking petrol pump, which is more attractive, and people will find it nice to see the car owners, and they'll come more likely there to come to my petrol pump rather than go to some other petrol pump. Okay, so anything where a new design or shape is given to that product which has no functional benefit but makes it look good, such designs are registered through an industrial design registration. Okay, I hope the difference between patents and designs is fairly clear. We are going to look at examples in the next few slides which will further clarify this. Next type of IP right that you're looking at is trademarks for brands, logos, word marks, taglines. Okay, now whatever marks that you use to promote, to identify the source of origin of your product or service that you're selling as an entrepreneur or as a business or an individual person into business, you are providing certain goods or services, and you want to build a unique brand identity for that. Okay, such things, the marks which identify the source of origin of that product or service and help you with your brand building, such as logos, word marks, taglines, etc., those are protected through a trademark registration. Okay. uh, Now, fourth one is copyrights for literary and artistic works, including software. Software means software programs itself, not the software concept idea, but the program. Okay? So, suppose you've written a book, a story book, a novel, or you have written a book which explains how to make a mobile phone. Okay. Or if you have created artistic works such as a painting or a sculpture, or you have taken an artistic photograph, these are all express works. Suppose you have made a song recording, you got an idea for lyrics for a song, and then you had some friends play some instruments, created music, and then you recorded a song. Finally, you have at the end a song recording, audio recording, song recording, which you and other people, once they get a copy, they can play. Okay, so it's an expressed work, it's fixed in a certain file. The audio file is a fixed expression of this artistic work called a song, right? Now that is protected through the copyright. Now, uh, please note, copyright is for protecting expressed works, which where the expression of the work is fixed in a certain form. For example, for a story, it will be a book that you have created. For a song recording, it will be an audio file, which is a express thing. You can actually physically copy, transfer, and listen to that audio file. Okay, a photograph has a physical form, either digitally, or you can print it on photographic paper and you can touch it and see it and experience that photograph. Or a sculpture, you can touch a sculpture, right? So these are expressed works. The value of the work is in the expression. Similarly, if you make a audio visual recording or a movie, now here again, somebody has made a video recording or a movie. That's again an express form having two things: moving pictures, motion pictures, and audio, which might include songs, dialogues, etc., and other music or other noises, etc. So it's an audio visual recording. Now all these works are expressed works. The value of this work is in the expression and somebody perceiving the expression. They have usually no other value except somebody perceiving that expression. Now what do I mean expression and perceiving that expression? For example, if you have written a story as a book and you published a physical book, the expression there is the published book form, which has many pages. Within each pages there are paragraphs, there are sentences, there are phrases, there are words, there might be some photos, there might be some drawings, there might be some tables. Now all these things are express work. The expression is fixed. Even after 10 years, 20, 50 years, you pick up that book, the words, the paragraphs, etc., inside the book will be the same. There won't be any change. So this is the expression, it's in written form. Okay, now what I talked about, the other thing called perceiving the expression. Okay, now what is this perceiving the expression? Suppose it's a book, how you perceive the book is by reading the book. Okay, suppose it's a photograph, how do you perceive a photograph? By seeing it, by looking at it. If the work you have created, copyrightable work, the expressed work you have created is a song recording, which means an audio file, how you perceive it is by listening to that audio file, right? If it's a motion picture, if it's a movie, how you perceive that file is by seeing the movie, the video playing, and listening to the song. This is how you perceive it. And suppose the work that you have created, expressed work that you have created, is a sculpture. How do you perceive it? You can perceive it by looking at it, as well as you can perceive it by touching with your hand. Somebody who's visually challenged can also perceive a sculpture by touching the various parts of the sculpture. Okay, so copyrights are for protecting expressed works, where the value of the work is in the expression, and the perception value of the work is in perceiving the expression. For example, if I go and watch a movie, I perceive it, I see it. At the end, what functional benefit do I get? Do I have more money after I finished watching the movie? Or if I was feeling unwell, I have some disease, does my disease get cured by watching a movie? Or if I'm looking for a job, by watching the movie, do I get a job? Means by watching the movie, there is no functional benefit to it. The value I get is in perceiving the expression itself. Just looking and hearing the movie is the value I get. The value I get is emotional in nature rather than a functional or a working benefit. It's an emotional value. I enjoy looking at good movies. I like looking at good photographs. I enjoy listening to good songs. That's the value that I get, and that's all the value there is in such a work, right? Now, so copyright is for protecting such expressed works where the value of the work is in the expression itself, right? I hope I'm audible to everybody very clear. Yeah.
Yes, sir, you're audible.
Okay. Okay. Right. Yeah. So these are the 4 types of intellectual property rights for the different types of intellectual property. Now, if you have written a book, don't go and file a patent for that. Okay. If you have created, applied a new design to a product which is merely good looking, doesn't make a difference to the working, don't go and file a patent for that. You should file an industrial design. If you have created a logo for product, promoting a products and services, don't go and file a design or a copyright or a patent, file a trademark application for that. Now this aspect will be highlighted and clarified in the next slide. Okay. Now this is an example of, suppose I have created some intellectual property. I've got some idea in my brain relating to something. What IPR should I apply for? Okay. Suppose I have created a new product design. The question is, should I side of the screen, you see a plain glass, assume that is already known, widely known, nothing new and innovative about it. And in the center of the screen, I have created a new design for the glass, which is very aesthetic, nice curved shape with certain engravings and markings, etc., which makes the design looks much better, more attractive. In other words, it's an aesthetic design. The question is, what IPR should I file for? Patent right or an industrial design registration? What should I apply for? Now, most people will agree, since there is no functional benefit of having a good looking aesthetic design, the benefit is only in terms of aesthetics. It looks better. Emotionally, people enjoy looking at good designs. So the benefit is only in terms of the aesthetics, the appearance, the shape. There is no functional benefit. If I drink some water or some liquid from it, from this curved shaped glass in the center of the screen, just because I'm using a good looking glass, the water or the liquid will not taste better or different. Or if it's hot, it will not taste cold, or it will not taste more salty or sweet or something. It will taste the same way. Functionally, the glass in the center of the screen, good looking and attractive shape, works the same way. There's no functional benefit out of this new design. So therefore, I would file for an industrial design registration. Okay. Now let's go further in this example. On the right side of the screen, now you see the same old plain glass on the left side of the screen, but this one has a handle attached to it. Okay. Now the question that arises is, for this glass, new glass design, which is the same old plain glass, known glass, with a handle attached to it, which is a new feature. For this new design, should I file a patent or a design application? That's the question that arises. Okay. Now let's look at it. Does it make sense to file a patent or a design, or is it eligible for a patent or an industrial design registration? Let's look at that. Now, if you, yes, would anybody like to say anything on this? Do you think we should file a patent or a design registration for this?
We should file patent.
We should file a patent. Okay, great. Why are you saying that, ma'am?
So that the design should not be copied.
Design should not be copied. Okay, so that's why we file any IPR, patent or design or copyright, we file so that it doesn't get copied. But why would you say okay, a patent should be filed and not a design industrial design registration? Hello, ma'am. Yeah, my follow-up query to you is this: okay, why did you say a patent application should be filed and not an industrial design registration? Why would you say that? Okay, let me address it this way. Okay, now You said that a patent application should be filed. The reason for that probably is the fact that, as you can see, this is not a new aesthetic design. This is a functional improvement in the design of the plain glass, whereby we have put a handle to it. And the benefit of having a handle, the functional benefit of having a handle is, for example, if I'm drinking a hot liquid or a hot water or tea from this glass with a handle, it's easier, more convenient and comfortable for me to hold the glass with the handle and drink the hot liquid or tea, rather than hold the glass itself, the plain glass on the left. If I'm holding a plain glass on the left and the liquid or the tea is very hot, my fingers will get burned. It's not very comfortable, right? But having the glass on the right, plain glass with a handle, I can hold the handle, the liquid or tea may be very hot, but my fingers don't get burned. It's more convenient and comfortable for me. In other words, the functionality, the working of the glass has improved because of this new design which incorporates a handle. Okay, so because of this new design which has a handle built in, the working functionality, benefit, results, advantage of the glass has improved, right? So therefore we can file and get a patent for this technological advancement having a functional benefit, a use, a utility. It's useful. Putting the handle is a useful thing. It's not merely good looking, right? Okay, now the other question is, can we file a design application for this? Is this an aesthetic design which can be registered as an industrial design also? Now most people will say, you know what, this is not an aesthetic design, so how can we file a design application? But that's a valid point you're making. Most people will say, you know, it's a plain old design with a handle which has a functional benefit. Therefore, design, it's not an aesthetic new design. You shouldn't file a design application. But consider this. How does the examiner at the design registry look at this new design? What is the interpretation of the word aesthetic when it comes to a design examiner at the design office? Okay. For a design examiner at the design office, aesthetic means some new shape given to an industrial product which looks different from existing products. That is how they interpret aesthetic. Because the point is this, aesthetics are a very subjective thing. There's no objectivity about aesthetics, right? So let's take this example itself to illustrate this point. Most people will say aesthetically this is not a better design, this is not a good looking design, it doesn't look good. In fact, some people will say, oh, with the handle, that odd kind of shape on one side, it's not even symmetric. Yeah, so this is not aesthetic. In fact, it's unaesthetic, it's uglier looking than the plain glass. Some people will say that. Okay, but then this is a matter of those people's perception and their point of view, okay, and their thinking, right? I might have a view and a perception that this glass on the right side is really so attractive and aesthetic, and my thing is not based only on the looks. My view, my way of looking at this is also through my mind's eye. I can see that having the handle makes this glass work better, and I might find that very beautiful. So I might find, okay, contrary to some other people, that this is a very aesthetic, good design, which I like to look at and use this glass. So in my view, this is a very good, different aesthetic design. So get this, this is how the design examiner at the design office looks at it. Anything that looks different from existing designs is considered aesthetic, as long as it's different, it's not a copy of existing design. So they will allow you to register the design of it. Okay. In other words, you can both file a patent application for this glass on the right side with the handle, as well as you can file an industrial design registration. If you decide to do both, you better file it on the same day. Okay. So to avoid one becoming a prior art for the other thing. Okay. Now, can you think of a product for which, another different product for which you can file both a patent application and a design application? Okay, because there's a functional benefit to it, as well as it looks different or good, and you can file both of these. But by filing only a design application, you can also protect the functional aspect. Normally a design application is meant to protect only the appearance, the shape of it, but by filing a design application for a product or new design which you can file a patent for as well as a design. Can you tell me what is that product for which by filing only design registration you can get a benefits of filing a patent also? Means the shape of it is so unique and so critical for the functional benefit that only filing a design registration on the shape gives you protection, like almost like a patent. It's a there is a very commonly used kind of a product which probably is already there in the room in which you are sitting. You might actually be using that product right now. Such a product, if you apply for a design registration for a new shape, you get protection almost equivalent to a patent. Can you think of that and tell me that example? Okay, let's continue in this slide and we will see that. Look at the bottom of the screen now, this slide. Okay, here we see on the left side a regular plain fan, straight blade design, and on the right side we see a fan with the curved shape design. Okay, now what's the difference between the fan on the left and right? The shape of the fan blades, the curvature. On the right side is a design which is curved shape and actually looks different aesthetically. The shape is different from the fan on the left. Okay, and not just that, because of this aerodynamic curved shape design of the fan blades on the right side, it, guess what happens, it actually circulates more air. And what's the basic functionality of a fan? To circulate air, right? And if you come up with the curved shaped dynamic design to the blade which circulates more air, guess what happens? The functionality of the fan is improved because of this new shape design of the fan blades. Correct? Right? So because of this new shaped blade design, you have a good looking aesthetic fan, as well as you have a better working more air circulating fan design. So you can see that you can file a patent application as well as a design application for this fan on the right side, right? But then the question is, which one will you actually file? Will you file a patent application, leave it, or will you file a design application and leave it, or will you file both the application? Okay, now when you're thinking about this, consider how a businessman or an entrepreneur will look at this. Business people, entrepreneurs, and even business people who have a lot of money don't want to spend and waste money unnecessarily. They want to invest an X amount and get maximum return on that. They always look to this ratio of investment versus what return you expect to get on that. A businessman in this scenario will quickly understand the situation and decide about what type of IP right to file for, a patent or a design, and what they will opt for is a industrial design registration, because the businessman within a few seconds will see, if I file a design application on this shape of this fan with these kind of blades, nobody else will be able to make a blade with this kind of a shape, this kind of a design of the blades. Okay, and if they can't make the blades and or the fan with this kind of a shape, they will not get the functional benefit, right? So by filing a design application, I get the protection of an industrial design registration on the shape, as well as I get protection on the functional benefit, or what protection I would have got through a patent. It's not exactly like a patent filing a design application. The protection is not exactly to the same level. Maybe it's about 60 to 70% of the protection, okay, that you will get through a design registration. It's only 60 to 70% of the protection you'll get through a patent in this case. But businessman will say, consider what factors, let me look at how much it costs to file and obtain a industrial design certificate registration, and how much time and effort and money it takes to file and obtain a patent a grant certificate. There you will see that the patent takes much more time, takes much more effort, and takes much more money to file, prosecute, and obtain the certificate. Comparatively, a design takes much less time, is easier to do, and it costs much less money. So maybe for 1/10 or 1/20th the cost of a patent application, you can file a design application, get it registered, and get maybe 60 to 70% benefits of the patent also. You'll get protection on the shape, industrial design protection, as well as 60 to 70% benefit of the patent, not by filing a patent, but by filing an industrial design application, because the nature of this product is such, right? So businessman will immediately decide, I don't want to file a patent, even though I can. I'll file only a design application. I'll get protection on the aesthetic design as well as the functional benefit because it's dependent on the shape. I'll get 60 to 70% benefit of a patent by spending 1/10 the cost in terms of time, effort, and money. So I'll file only a design application. Decision is made. The businessman proceeds with the next thing on his or her agenda. Okay. Now let's look at this next example of what IPR right should I file for. I have created a new logo and a tagline for a product. Should I file for copyright or should I file for trademark registration? Okay. Suppose you create a new logo and tagline for a product. Should you file for copyright or for trademark registration? Now, most of you would have guessed what these image and the phrase on the right relates to. On the left side is an image, okay, a picture of something. It's most of you would have guessed it's a mark, it's a logo used by the company Nike to sell its shoes and other products, sports related products. So this is the swoosh mark of Nike, the company Nike. And on the right side is a phrase which again is used by the company Nike to promote its product or to identify the source of origin of the product, that it comes from Nike. Because anytime, suppose I'm traveling outside, maybe in a bus or something, I see the swoosh logo somewhere, either on a billboard or on somebody's bag or somewhere. I see the swoosh logo. Immediately, even if I don't see the name Nike, I know, okay, this is a Nike product, right? I see the phrase "just do it" somewhere. Immediately, it reminds me of Nike. So the consumers are reminded of the company and the products that it offers every time they come across either this logo or this phrase, just do it, right? That's the whole purpose of branding, creating an image building, brand building, identifying that these good quality products having these characteristics and specifications are coming from this source, Nike, and the unique mark identifies that. And other companies other than Nike are not allowed to use these marks for even if they are selling shoes, because these marks are registered as a trademark. Now the question is, on the left side you see an image, and we saw that a photograph or an image you can very well register as a copyright. We also saw that books or phrases or sentences or paragraphs or something like "just do it," it's a phrase, it's a group of words, they can very well be copyrighted. The question is, will you file or Nike file a copyright or a trademark application? Now here the answer is based on these marks. Okay, right? Now these marks are used by Nike to protect or to promote the products and services and identify that and do the branding for the products that they are selling. So this is used more in the nature of a trademark rather than merely as a copyrighted work. Nobody publishes a book with the logo and sells that for money. Nobody will pay them for getting the swoosh logo or hearing the phrase "just do it." They are using these marks to promote their products. So therefore a trademark registration makes more sense for Nike rather than a copyright, although they can very well go and file for a copyright. The problem with copyright is it has a limited term, that is 60 years after the death of the author of the copyrightable work. So it has a limited term. On the other hand, a trademark has a term which is unlimited. As long as a company or a person continues to use the trademark and keeps on renewing it every 10 years, the trademark can continue indefinitely for 100, 200 years. For example, people don't live 100, 200 years, but companies can survive for 100, 200, 300 years. So if a company is constantly using these trademarks, they can continue using indefinitely the trademark. Now, one thing I would just like to go back and again highlight to you about these IPR right types is, on the screen of the 4 different types of IP rights, there is a distinction, important distinction between the first 2 rights and the second 2. In case of patents and designs, you don't get automatic protection on your intellectual property till the time you file a patent application or industrial design application before you bring out this invention or this new design in public or use it in public. So once you've created the intellectual property, got the idea for the technological invention or the new design, before using it in public or making it public, you have to, if you want to protect that invention or that design, you should first file for a patent or industrial design, only then make it public. Till that time you have to keep it secret, your invention or your design. Only then you can, once you have applied for registration, you can go and disclose in public. In case of trademarks and copyrights, there's no need for secrecy. You can start using a trademark, design a trademark logo or a wordmark, use it for 10 years. After 10 years, you can go and apply for registration. Trademarks accrue to you when actually you use these marks in connection with some trade, some product or service that you're providing in the market. Similarly, copyright. If you create a expressed work like a book or a movie or a sound recording or a software program, source code, you get copyright on that automatically. You may go and register it or not register it, or you may register it after 5 years or 2 years. Does not matter. You still have the rights. So prior disclosure and usage is not a problem when it comes to trademarks for brands or copyrights for expressed works. But in case of invention and aesthetic design, if you want to protect that invention or design, first you must file for a patent application or an industrial design and disclose it only after that. Otherwise, you will permanently lose the right to file and obtain a patent or an industrial design registration. This is a very important thing to understand. Let's go further in our presentation. So here, this particular slides highlights the fact that one thing or product can have multiple IP rights associated with it. It's not as if एक item, one product is there, you can have only one type of IP right. Okay, you can have multiple IP right. For example, in this case, this on the left side is a bottle of some juice or drink. Okay, the patent will protect the process of making the drink as well as the final product, the composition itself, the juice itself, the drink itself that is produced. Okay, can be protected through patent. The specific design of the bottle will be protected under industrial design. The particular shape of the bottle will be protected through industrial design registration. The trademark registration will protect the name and logo of the drink. That is the Welch's, which is written on a certain style, you know. And a jingle made for the advertisement of the drink will be protected by copyright. Jingle means some song to promote this particular drink, which may be played on TV or on radio or on the internet. Okay, that is a expressed work. It's a song. Jingle is a song which will be protected by copyright. And this drink is produced from grapes specially grown in a region called Concord. Hence, that word Concord can be used in association with the drink, and that word Concord, which identifies the geographical origin of the product, from where this product has come. That's called a mark which indicates, Concord is a mark which indicates that this drink has been sourced from this particular area, this region of France. Okay, so that is known as a geographical indication. You can have a geographical indication registration also for this. Okay, so one thing, one product can have multiple IP rights associated with it. Okay? Now, let's focus more specifically on aspects related to patents itself. We have looked at the various types of IPR, 4 types of IPR: patents, trademarks, designs, and copyrights. Now, let's focus more on patents, because very often for entrepreneurs or technologies or people setting up technological ventures, patents are the most important. In obviously other things, especially trademarks, are also important, but today let's focus more from now onwards on the patents. Okay, so patents are the right, intellectual property right, for the type of intellectual property called an invention, which itself has to either be a product or a process. Okay, what can be an invention, a product, or a process? What are the 3 main criteria for grant of a patent for your invention? The invention should be new, inventive, and useful. Okay, now most people don't have a problem with their product or process being useful, because they have created it to solve some problem and provide some useful benefit to their users. Okay, but the aspect of new and inventive, let's be clear about this, these are absolute requirements. Means the product should not be publicly used or disclosed anywhere in the world as of the date of filing of your patent application. Hello, anybody wants to say anything? Okay, maybe somebody's got unmuted or something. Okay, so the requirement of the invention being new and inventive is absolute. Okay, nobody in the world should have either publicly used or disclosed this particular technology or invention. They don't need to make it. Even a disclosure about some new product or process counts as making the invention not new and not inventive, in other words, old. Many people come to us and say, you know what, I want to patent a new product that I have created, Okay, it's not there in the market in India, it's not known in India, it's known in the US. Okay, but not known in India, not in the market in India. Can I get a patent? The answer to that is no. Anything that is known in the US or in Japan or any part of the world is considered as being known in India in this internet age, because you can guess how what fraction of a second it takes for some information which is known in Japan or Australia or USA to reach India. It won't take 1 second for it to reach India over the internet. So anything known anywhere in the world is considered as known and old in India as well as the whole world. Therefore, you can't get a patent on that. Okay? As we discussed just now, registration is very, very important. In fact, you should apply for registration of the patent on the invention before you make that technology uh, publicly and distribute it, or you give out any information about that technology publicly or publish it anywhere. Keep it secret, file the patent application. After filing the application, getting the filing receipt, you can then go and disclose it, make it, launch it, tell people about it, put it on your website, information about that new product or technology. You can do that, but that is after filing the patent application. When to file? Before public use or disclosure. What is the term of the patent? The patent term is 20 years from the date of filing of the application. Okay. Now, actually, what happens is when you file a patent application, usually it takes a few years, 2, 3, 4, 5 years for the patent to be processed, examined, and granted or rejected. So effectively, your patent term will be 20 years minus how many years it took for the patent to be granted. So if it took 4 years, your effective patent term will be 20 years minus 4 years, that is 16 years is the patent term. So it's a monopoly right for a limited term, not permanently. You created an invention, you get a patent on that. The patent right doesn't survive for more than 20 years. It doesn't survive for 50 years or 100 years like a trademark can. Okay, so this is one thing to note about a patent right. It's a monopoly right. Government generally don't want to have monopoly, they want to break monopolies. But here is a case where the government gives a monopoly right to inventors, but subject to certain terms and conditions. One is the maximum term of the patent right will be 20 years, as well as important condition is to get that right, you have to provide a complete detailed enabling disclosure of your invention. Okay, and it should go through the process of patent examination. Only then the patent right is granted. Okay, so these are the terms and conditions to which a patent is subject. Okay, what are the requirements for drafting and filing a patent application? You need a technical invention description in detail along with drawings of the invention or drawings which help explain the invention. Based on this, a patent application can be drafted and filed with the patent office. Okay. What is the procedure? You file a you draft and file a patent application. In 18 months, it gets published by the patent office. Then it undergoes examination. And then after a few years, usually, there is a final decision either granting a patent or rejecting it. Okay. There's an optional procedure you can do before you file an application or even later, in fact, which is a patentability search. We saw just now the criteria, newness and inventiveness is essential to get a patent. Now you might say, okay, I have created a new improved product. As far as I know, it's new and inventive. I've not seen anything like this anywhere in the world. But I'm not sure whether in some corner of India or the world, somebody else has done already something like this. How do I check this? Now, how you check that is by doing a patentability search of worldwide databases, not just in India. You have to do a search of worldwide databases. This you can very well do yourself on the internet, where there's a lot of information available, patent literature related to the various patent offices, as well as non-patent scientific and technical literature that's available. And you can see whether this idea is already in public domain. This concept invention is in public domain. Okay, and such a search is called a patentability search. The costs, there are separate costs related to searching, filing, replying to objections in the examination report. And once a patent is granted, there are separate costs for renewal of the patent application to, or the granted patent to keep it in force. What are the timelines? In about 18 months after filing, after 18 months, the application is published on the patent office website. Whatever patent application you filed with the patent office, they'll put it up on their website. Then the application will be examined. Okay, they'll raise objections, we have to reply to that, and after that a final decision will come. usually after a few years in the normal course, unless you go for an expedited examination, there are certain procedures. Important thing to note is by filing and getting a patent in India, you don't have the right to stop people in other countries from copying your invention. An Indian patent, if you get, you can stop copiers only in India. Patents are territorial. Okay, but India and most major countries of the world are members of the Paris Convention and Patent Cooperation Treaty, PCT. These are international agreements signed by India and most major countries, whereby they give reciprocal rights to each other. So once I do an Indian filing, I get 12 months time to do foreign filings under the Paris Convention. And if I need more time to do foreign filings, I can file what is called a PCT application and get 18 months additional time to do foreign filings. To put it in brief, please be aware, Indian patent valid only in India. If you need to protect your invention, stop copying in other countries, because you see your product can be used in other countries also, then you need to file patents separately there, and there are international treaties and conventions to facilitate foreign filings. Be aware of that. We don't have enough time in this session to go into the details of this, but be aware of this. And the foreign filing cost in each country and for the PCT are different for each country. Okay, and not every idea can be patent. There are certain exclusions as per Indian patent law. For example, if the technology is sensitive, such as nuclear technology or atomic technology or defense related technology, the government may not allow that, the patent office may not allow that. Or if it is something which is harmful to the health of somebody, if some product is there, or if it is some immoral, some technology which will lead to some problems, or some such things are not allowed to be patented. Business methods are not allowed to be patented. Methods, medical treatment methods for human beings and animals are not allowed to be patented. Medical compositions, medicines or medical devices can be patented, but methods of treating people and animals are not allowed to be patented. So there are certain exclusions to what can be patented. Okay, let's go to the next slide. Okay. Here we are looking at a little certain aspects about when we talk about patenting, what exactly is an invention. Firstly, look at the word invent, which from which invention comes. Invent is create by thought, originate. Okay, invention doesn't mean you have to make a physical product, not required. You just have to get an idea in your head for a physical product or a process of making or doing something. You document there, and guess what? Invention is over. Right? You get an idea for a new product or process and you document, invention is over, finished. And because invention is finished, with that documentation, you can draft a patent application and file it with the patent office. You don't need to physically make that product or actually practice and test out the process to be able to file a patent application. You don't need that, right? Get the idea, document it, give it to somebody to draft a proper patent specification and file it with the patent office. You don't need a prototype, demo or model. Physical construction is not necessary. Okay. Also, let's understand the difference between invention or creating something and merely discovering something. Okay, let's look at the example of solar radiation. Okay, if imagine there's a team of researchers which researches solar radiation for 2 years, and they discover the characteristics and properties of solar radiation, and then they publish a research paper documenting the characteristics and properties of solar radiation. Now, this kind of a research paper, is it a patentable invention? That's the question that arises. The answer to that is it's not a patentable invention, because they have merely documented the characteristics of solar radiation. They didn't invent solar radiation. They didn't create solar radiation. In fact, the sun and solar radiation have existed for billions of years. Human beings have existed maybe a million years or even less than that, right? So what these people, team of scientists and researchers, PhDs have done is they have studied solar radiation and understood the properties and characteristics of it, and they've documented that. They haven't created a new product or process. They have merely discovered the properties of something which has existed for billions of years. Therefore, there is no invention to patent because there's no product or process, right? But in that document, it so happens they have discovered certain characteristics of solar radiation. One important aspect of that is solar radiation is not one thing. It's made of actually different things. Two main things it's made up of is, one is there is electromagnetic properties or characteristics of solar radiation. Okay, so solar radiation actually comprises in one aspect electromagnetic waves, waveform. Another aspect of solar radiation is energy particles called photons with a certain level of energy built into it. So these researchers have discovered this. Imagine this research was done 100 or 2 years, 200 years back. That's how they discovered this, and they published a research paper on this. So now they have discovered and documented that solar radiation is made up of two main things. One is a electromagnetic waveform. Second is energy particles, discrete particles of energy called photons, which carry energy in them, right? Now, all this is documented, very useful, valuable work, but no product or process to patent. Okay. But imagine in another part of the world, there is a team of engineers and technologists, applications people, not basic researchers, but applications people, engineers, technology. They apply technology, make useful products, and their mind starts working when they read this research paper regarding solar radiation. They see that, okay, solar radiation has this thing called energy particles called photons. And then that document already, research paper also tells them, photons have this much energy. So 10 minutes on, 1 square inch of radiation for 10 minutes on some device, so much energy through the photons will be incident on that 1 inch of that particular receiving device. So then these people think, can we capture that energy and use it for some useful purpose? Because human beings are hungry for energy. Energy is required for anything and everything. To do anything, we need energy. More and more power supply is required. So then this team of researchers comes up with an idea for a solar heater. Okay, solar heater could be for heating, cooking food or heating water, or it could be photovoltaic panels, PV panels, to capture that energy, store it in a battery and use it to run some devices, some sort of solar heater they think of. And then they actually document not the characteristics of solar radiation or something, discovery like that, but they are physically designing, devising and documenting and writing about, we are making a solar heater. The solar heater has these parts, it has this reflector to capture the energy. Then that reflector focuses on this device in a very concentrated form, which itself can absorb the energy at so much rate, and then it heats either the food or the water, or it stores that energy. Then there is this piping to make this happen. And because the sun is moving across the sky the whole day, they have a mechanism such that the heater reflector also moves will along with the sun the whole day. So there are these physical parts, can you see, to make this device. It's a physical device which you can go and touch once it's made, right? So they document the different parts. They make a drawing of this solar heater device, okay, which will help somebody reading that document and looking at those drawings to actually make it. Can you see there is a physical product that they have designed here and documented? And now, based on that documentation, they can file for a patent or obtain a patent on this solar heater. Please note, you don't need to physically make this solar heater. The inventor just needs to get the idea, design it, think of all the parts, document it, make the drawings, and then based on that document and the drawings, go and draft and file a patent application and get a patent. You don't need to physically make the prototype, test it, make the model, have proof of not required for patent. To convince a buyer, you may need the physical model or prototype, but for getting a patent, you don't need a model. Very important to understand this. Okay, I hope this aspect is very clear to you as to what is an invention and what can be patented. Okay. Another important thing to note about inventions and patents which are granted on invention is these inventions should relate to the technological arts. Innovations which are technological in nature, new innovative products or processes, can be patented. Social innovation, I'll have this kind of model to collect money like this and distribute to the needy people on this basis. This is a social innovation, economic innovation. This will not be patentable. But an innovation related to some technology, I'll make a product like this, or have a process for making a product or a device like this, those are patentable, right? Please remember this. Business innovations are not patentable. I'll do share trading like this, I'll buy share from this exchange like this, and I'll take advantage of this arbitrary opportunity on the other and manage this and do this innovative thing and get such. This is the business trading related financial innovation, not patentable. Only technological innovations are inventions and therefore patentable. Please remember. And most inventions are improvements, additions to existing technologies. This is very important. When you do your work later on, remember, you don't need to always come up with the entirely new product from the ground up to be having an invention and patenting it. Many inventions which are in the nature of improvements can be patented. For example, the mobile phone itself is an invention. The whole product is an invention. But guess how many product patents could have been filed for the idea? Maybe 50, 60 years back, somebody came up with the idea for a mobile phone. How many patents could they have filed for the concept of this whole mobile phone? Only one. Once somebody invents mobile phone concepts, documents, and files a patent application, it becomes old public knowledge. Nobody can again file a patent for mobile phone. But can you imagine the number of patents which have been filed to technologies related to this mobile phone? Firstly, one mobile phone has multiple technologies. Okay, and people go on improving each of these technologies, and for each improvement they file patents, and they can very well obtain valuable patent which make them a lot of money. For example, somebody improves the display, as we saw earlier, to increase the resolution, double resolution. Displays are there, mobile, but somebody improves the display to give double resolution, they file a patent on that. Somebody again improves the display, but this time to improve the color reproduction of the screen. They file a patent for that. Somebody else improves the screen, but this time they use more environmentally friendly material in the display of the screen. Okay, that again is a technological innovation. It's causing less damage to environment. That's a very valuable technical invention. They file a patent for that. So can you see, one patent for file can be filed for the entire product, but parts of the product, improvement, innovations, there can be improvements, and you can file patent for each of those as long as there is some value mark, right? Very important to understand this. When you work later on ground up to be able to file and obtain a patent on your technology. Okay, now let's go to the next slide. Selvi ma'am, we have come to the end of our time as of now. I'm sorry firstly for the delay, but if you permit me, can I complete this in about say 10 minutes?
Yes, sir. No problem, sir. Go ahead, sir.
Okay, thank you very much, ma'am. Thank you for the extra time. Okay, so let's look here at a case study. Okay, this relates to some technology being created by somebody, a patent being filed for that technology, and then what happens once a patent is granted. And the invention itself, the new product or process or the technology or methodology that is created, what happens to it in the real world out there? That is what we are looking at. So this case study is about an organization called WRF, Washington Research Foundation, which, and another organization or company called CSR, which is Cambridge Silicon Radio, a company based in UK. Washington Research Foundation was a non-profit foundation, or is a non-profit foundation based in Washington State, USA. Okay, and let's look at what happened. As the title says, Washington Research Foundation earned $15 million from CSR based on its patented technology. Okay, this is the headline. Now, what does this illustrate, this point and this factor? This illustrates the fact that patents can have inventions, and the patents that are granted for it can have a lot of value, running into millions or even billions of rupees or dollars. Okay, broad headline message is that. Now let's look at some of the details of what happened in this case, which will be very interesting for you as students or researchers or entrepreneurs or as startups who create and develop technology and then are looking to commercialize it, get it out there in the world. Look at how things work generally. Okay, so first let's look at the technology or the patent background. What is this technology that we are talking about, on which WRF earned $15 million from only one company called CSR? They earned more money from other companies also, but from this one company they earned $15 million. So this technology relates to Bluetooth technology. Okay, now what is this Bluetooth technology? It's a technology pretty much all of us are using even today in our devices, electronic devices such as mobile phones, laptops, Or for example, if we have these wireless headphones, I'm using a wired headphone, but you have these wireless headphones. How does my headphone communicate with my mobile? Using Bluetooth wireless communication technology. Now you'll say there are dozens of wireless technologies, but please understand, this is not the normal internet technology that is used in Bluetooth. It's not the Wi-Fi technology. This is a different technology called Bluetooth technology, okay, which is suitable for use in electronic devices which are not too far away, okay, which are in close proximity. It's very easy and very convenient to use, consumes very little power. This is the benefit of this kind of wireless technology compared to other wireless technologies. Also, Bluetooth signals are not very harmful to people, so they are good for using in these kind of scenarios where, for example, my headphone is inside my ear, very close to my brain. I don't want a wireless technology which emits very strong wireless radiation. I don't want that. So Bluetooth is harmless and very useful for these kind of things, very easy to use for in devices which are in close proximity, maybe a few feet of distance or 10-15 feet of distance. Okay, so this is the basic technology that is involved and that was invented and patented. Okay, so Bluetooth technology uses radio frequency to enable mobile phones and other electronic gadgets to talk to each other and transmit data over short distances without the need for wires. So this is the basic technology which was created, and patents were granted for this RF receiver technology, called the trademark name given to it was Bluetooth. Okay, but the technology was radio frequency receiver, sending and receiving technology, conversion, etc. Okay, which are used in Bluetooth chips. Okay, this patents were granted for this invention, which was invented in the 1990s, and patents were filed in the 1990s. The patents might have been granted in the late 1990s or in the early 2000s, because it takes time after you file a patent, and this was mainly in the US. It takes time after you file a patent for the patents to be granted and registered. Now, who was the inventor? The inventor was a student and researcher studying at the University of Washington. Okay, his name was Edwin Suominen. This was the name of the student and researcher who was studying at Washington, University of Washington in the 1990s. Came up with this technology, RF receiver technology. Trademark name is Bluetooth technology. He applied for patents, or rather the university applied the patents, because the student gave away the rights. As an inventor, he would by default have been the owner and applicant of the patent, but he didn't want to spend money, or he might not have seen great value for this technology at that time, because being a student and not thinking of being an entrepreneur or setting up a startup, he might not have realized the potential commercial value of this invention and the patents that are filed on it. So he gave away the right of his invention to the University of Washington, which filed the application with the US Patent Office, wherein the inventor name was Edwin Suominen and the applicant or owner of the patent name was University of Washington. So University of Washington had all ownership right, applicant rights on this technologies, for which more than one patents were filed in the 1990s. Okay, and Edwin Suominen moved on. He studied, finished his education at the university, moved on and went somewhere else. University of Washington was left with these patent applications, for which it was spending time and money to obtain the patent, and they assigned these patents which were obtained and all rights related to licensing to a foundation called Washington Research Foundation, WRF. Okay, now why would the University of Washington license or give away the rights for licensing this technology to companies to a foundation, right? Because University of Washington, what is its main activity or business? It is education and research. They are really not into having a big distribution marketing network to go and approach companies, ask them, discuss with them, negotiate, license my technology, do a commercial negotiation, prospect, then collect the license. University of Washington is not in that business. Okay, they are in the business of providing education and research facilities, encouraging education and research. So they focus on that. This part about handling the patents, licensing it, negotiating, prospecting for potential licensees, making sure they give the thing, enforcing the patent, filing cases against people who are infringing the patent without a license. All this work the university doesn't want to get into. Okay, so they gave WRF the right to license this technology to other companies. That's what WRF was doing. It was looking at whom can I license this to? Is somebody infringing? Should we take legal action against them? This was what was being done by the Washington Research Foundation. Now, please note, this is one model which a educational institute or a research institute or university may follow. Another model could be, for example, and this was in the 1990s, mid 1990s or so. So at that time, the awareness about students and researchers in educational and research institutes setting up startup was there, but not much. Okay, that's why this student Edwin Suominen didn't think of, okay, let me start up my own company, let me have a startup with me and a team of my colleagues or co-students or faculty, and that startup will actually commercialize or make and sell or promote or patent and do this. Instead of that, what he did is assigned it to University of Washington, and it was out of his hands, right? In current times, the students or the team of students and faculty who come up with innovations like this may very well set up a startup and get into entrepreneurship to make sure that this technology, which is there as an idea and on paper for which patent has been filed, we actually work towards implementing it and bringing it out into the market, or maybe even licensing to other companies who can do that. Okay, so please note, these are the possibilities that are there with an invention. These are things, these are the various routes that can be taken to commercialize or bring that technology out into the market. Okay, now let's look at what happened in this scenario. Now we have got a background of the technology, the patents, who was the inventor, who was the applicant, and which was the entity which was authorized to license this technology. Okay, let's go to the next slide. Okay, patent licensing, infringement, and settlement. Okay, technology invented, patents obtained, everything in place. Now it comes to licensing, infringement, and settlement. Okay, WRF had licensed the technology to Broadcom, okay, which is again a chip manufacturing company, which is a competitor of CSR, right? It's not that only one company makes Bluetooth technology based chips. There are many companies, like in any industry, there are many companies which offer the same kind of products or services. So Broadcom was a company which was in this business, which WRF approached, or Broadcom approached WRF, and Broadcom had a valid license to make and sell this technology, and they were paying a license fee to WRF, which probably WRF was sharing with the University of Washington. That's the terms and conditions based on which the university had allowed WRF to do the licensing. Okay, you do the licensing, get the revenues, license revenues, and share so much percentage with the University of Washington. That's what was happening. Now, this company is a competitor of CSR and had licensed the technology. But what was happening with CSR, Cambridge Silicon Radio? That CSR had not licensed this technology. And by the way, CSR was a UK-based company, which was a fabless semiconductor company selling microchips which utilized Bluetooth technologies. Okay. Now, semiconductors, we know these are chips which go into our computers, phones, and other electronic devices, which provide different types of functionality. One chip is a microprocessor. Another type of chip is a memory chip, which provides storage memory, right? Another chip is a wireless communication technology chip. For example, one example is Bluetooth wireless communication technology chip, which is what CSR was selling. CSR made and sold different types of chip. One of them was a communication chip which went into mobile phones using Bluetooth technology. This was one of the things. And I have mentioned here that CSR was a fabless semiconductor company. Semiconductor company, we understand. Okay, now what is a fabless semiconductor company? Fabless means CSR itself was not making these chips, microchips. They didn't have a factory at all. They can't make the chip actually. What they would do is they would design these chips, semiconductor chip, these integrated circuits, which are very complicated kind of thing with literally, thousands, if not tens of thousands of parts and connections based on it. So designing itself is a challenge. They'll design it on paper. Okay. And the physically making the chip was done by some other company which focus on making these microchips, semiconductor technology. They have plants, factories. Maybe these factories are based in Taiwan or China or somewhere, or Japan. Okay, designed in the UK by CSR. The blueprint is given by CSR. And the actual manufacturing of the chips, which is a very highly specialized technology manufacturing facility, all these clean rooms and all those things, very sensitive equipment, that is done in Taiwan or China or Japan by some other company. Okay, and that company in Taiwan or China would make those things as per the design specification given by CSR, and CSR would get these chips and they would sell it to their customers. Okay, this was the business. Fabless means this: CSR was not fabricating this, it was getting it fabricated by somebody else. Somebody has unmuted themselves and there is some music song playing very loud. Please mute yourself. Okay, right. Okay, so this is the meaning of fabless semiconductor company. Okay, right. Now, what happened next? CSR's Bluetooth chips were being used by mobile phone firms like Nokia, Samsung, and Panasonic. Big clients it had, CSR, to which they were CSR was selling these Bluetooth chips for use in those phones. And remember, this Bluetooth technology is patented by University of Washington. WRF has the authority to license it, but CSR has not taken the license from WRF. They are infringing these patents, in other words, right? So what did WRF do when they saw that CSR is using this technology, selling these chips to Nokia, Samsung, and Panasonic, and these companies have launched phones which in the market out there and selling thousands of phones using these chips and this Bluetooth technology. WRF in December 2006 sued CSR's customer Nokia, Samsung, and Panasonic, right? In December 2006, WRF sued CSR's customers Nokia, Samsung, and Panasonic. The important question that arises at this time is, why is WRF suing CSR's customers like Nokia, Samsung, and Panasonic? And why is WRF not suing CSR itself? Because CSR is the main party which is initiating and doing this infringement. Nokia is merely buying some technology and chips from CSR without knowing what's there, whether it's patented or not. But CSR is the active entity which is doing this infringement. So why is WRF, why did they sue Nokia, Samsung, and Panasonic rather than CSR? Point to ponder, very important. Okay, the reason for this is simple. If WRF, I'm guessing, okay, there can be many reasons, I'm guessing one of the reasons. Suppose WRF were to sue CSR, okay, you are using this, designing these chips using our technology, getting it manufactured, then you are infringing by again selling it, right? So WRF could very well have sued CSR, but the point is CSR that way is a relatively small company, okay, and if they had talked to CSR or sued them, CSR would file a case in court counter claiming that patent is not invalid, or I'm not infringing your technology. That case would have gone on for a few months or a few years. Okay, in the meanwhile, WRF is getting nothing, right? Because that dispute will go on, discussions will go on, case will go on, WRF doesn't get anything. Okay, what's the better way of pressurizing CSR to pay up quickly? Don't sue CSR, sue their customers who are big companies who are very important for CSRs. Okay, and the moment a company like Nokia or Samsung or Panasonic gets sued for something which they haven't done, they just bought some technology which now some entity, foundation is suing them. Okay, you are using and selling in the market these infringing products. Then Nokia will get very upset with CSR. How are you? What has happened? Somebody has filed a case against us. We haven't done anything. They filed a case against us. Why have they filed against us? What have you done, CSR? What illegal thing have you done? Whose patents have you infringed? Why did you do? Why did you not tell us? Why didn't you have licensed technology? Nokia, Samsung, and Panasonic, the important big customers of CSR, are putting pressure on CSR as to what happened. Why are we being sued? Can you imagine the pressure on CSR to deal with this matter and settle it quickly, rather than WRF suing CSR, which is a relatively small company, and they'll discuss, negotiate, argue, file a counter case, do this, do that. Instead of that, sue their Nokia's CSR's customers. It directly hitting their business, and their valued customers are coming and putting pressure on CSR. Okay, what have you done? Why are we getting sued? Deal with this, settle this quickly, right? That's what it happened. So because of this factor, see, this is how business is done. people who sue somebody else or WRF, when it had to decide whom to sue, should we sue CSR, their customers, or the fabricators in Taiwan or China, they could have sued all of these parties. By the way, all of them are infringing the patent, right? They decided to sue where it will get them maximum results in the shortest possible point of time, which is the customers of CSR, right? Okay, so they sued that. So then what happened? December 2006, WFR filed a case, these cases against Nokia, Samsung, and Panasonic. Within a
Hello.
month, January 2007, CSR entered the case and counter-sued WFRF. Okay. Now, CSR itself
Selvi
was
ma'am.
not a party to the case. Yes,
Yeah,
is there somebody wants to say something?
Saurabh sir has joined.
Ajay has joined. Okay.
Okay.
I think,
Yes, ma'am.
sir, we can wind up within.
Yeah, within 2-3 minutes. We are almost done. This is the last slide.
Yeah.
Okay. And thank you very much.
Saurabh sir, sorry for the delay. Just 2 minutes, sir.
Okay. Yeah. So within 1 month, CSR entered the case, even though it is not the party being sued. They could have stayed out, but really they couldn't have, because their customers were putting pressure on them. So they entered the case and they counter-sued WRF. And when people who are accused of infringing a patent, they counter-sue, what they claim is, firstly, this patent is not valid, it was wrongly granted, so I want to invalidate the patent. Secondly, they'll claim what we are doing is different from the technology that they have patented. Our technology is different. These are the 2 points on which they will counter-sue and argue. This is what CSR did within a month because of the pressure they were under. And guess what? Within 3 months of that, CSR agreed to pay 15 million to end the lawsuit. Normally, these cases can go on for several months or even years. But here, they agreed to pay the $15 million to end the lawsuit, because that is the reflection of the kind of pressure they were facing from Nokia, Samsung, and Panasonic, their customers. And they didn't want to carry this long. They said, better we settle this matter, otherwise our customers are very unhappy. We have other customers to whom also we are selling. These people, WRF may go and sue those customers also. WRF may go and sue our fabricators in China or Taiwan. It will cause major problems. Better we settle this as soon as possible. So because of these reasons, CSR agreed to pay $15 million to end the lawsuit and got a commitment from WRF that they won't sue CSR, their customers, their fabricators, or anybody doing this through CSR. And that's how the matter settled. And apart from this $15 million, WRF made much more, lot of money from multiple other customers and users and parties who are using the Bluetooth technology. This gives a sense of the value that technologies and patents may have, and how people go about protecting and enforcing their technologies. Okay. With this, we come to the end of this session. If Selvi ma'am permits, if anybody has any questions, we can quickly address those. Otherwise, this session is completed, and we can move on to the next session. I'm sorry for the delay in completing this, and thank you very much for participating, for your attention, and to the college itself and the management and the principal and director for giving me this opportunity. And thank you, Selvi ma'am, also for supporting.
Thank you, sir. Siddhika, thank you, sir. Yeah, Siddhika.
We are very grateful that you have taken the time out of your busy schedule and shared your views and ideas about intellectual property rights. I'm sure your speech has enlightened the curiosity about this topic in many of us who wanted to explore this area. Your session was full of enthusiasm. Thank you so much, sir, for being a part of our workshop. Thank you so much, sir.
Thank you,
Thank you.
sir.
Sir, is there any international body where we can get international patent for all over the world instead of
Okay,
individual country patents?
Very good question. As I mentioned during the session, there are international treaty, Paris Convention and PCT. Okay. Now, PCT system is an international patent application filing system. Please note, it's not a patent grant system. It's merely a filing system. You can file and send your application to 150 member countries of the Patent Cooperation Treaty. But then within the extended period of 18 months, you have to go and file separate applications for grant in each of those countries where you're interested. Okay. So the answer to your question is no. There is no one place or organization for getting an international worldwide patent. No. there is something called a patent cooperation treaty, which is an international filing system whereby you file one application, it gets sent to 150 plus member countries of PCT.
So,
Yeah.
So why patents have a period? Why can't it be made for lifetime?
Sorry, you are saying why patents have a limited term?
Yeah. Why can't it be
Right.
made for lifetime?
Okay, very good question. This is what the governments have decided. Okay. See, please understand the nature of a patent right is a monopoly right to the patent owner or applicant, that without your permission, nobody in the world can use this patent in wherever, whichever country you have got the patent. So it's a monopoly that the government is giving to that patent owner, right? And you would be knowing that generally governments are against monopolies to anybody, right? Now, in this case, this is a special case where governments actually give patent applicants a monopoly, but what they do is, as I explained earlier, it's subject to certain terms and conditions. First is you have to file the application, disclose the technology to the patent office, which will get published there. And then it goes through a proper examination process for a few years, usually, or at least a few months. And then the other condition or limit they put on this monopoly is the term is limited. 20 years maximum is the term, because governments don't want to give unlimited monopolies for unlimited number of years. That's why the government has made this requirement. They could very well have given a term of 40 years or 50 years, but the governments across the world and international organizations have decided 20 years is fair, not more than that. Now, why? I don't know. This is what they have decided.
Sir, so there's a question now. Like you said, it's 20 years. It's like the minimum time. So can the patent be renewed like after 20 years?
No,
For the
it
same.
cannot be. That's the meaning. Maximum is 20 years. That's the problem. Trademark can be renewed every 10 years as long as you continue to use it and renew it, right?
Okay.
But not a patent. 20 years finished.
Thank you so much, sir.
Thank you, ma'am.
Now, thank you. Now I
Thank
would
you.
like to call Gauri to
Sorry for
introduce.
the delay and overextension.
No,
Sorry,
no
Mr.
problem, sir. No problem, sir. Thanks a lot.
Thank you.
Thank you so much, sir. Now I would like to call Gauri to introduce our second speaker, Saurabh Jain.
Thank you, Siddhika. Saurabh Jain is the founder of Fun to Do Labs, which believes in the motto, Happy Kids Learn More. It is the pioneering research into transmedia education. He is the ex-vice president at Paytm and was heading the Paytm Build for India's program. He had an active role in startup products, developer relations, and social impact within Paytm. He has also managed the relationships with various industry bodies. He, he is a chartered accountant with keen interest in technology and has authored 2 books on mobile application technology. He wrote Mobile Phone Programming, which was India's first book on mobile app programming. He is the inventor of Personal Persistent Messaging System (PPMS) and Neurosymbolic Network Generation and Execution System, for which he had got provisional patents. He has been a speaker and involved at different global events, Indian events, and also at IIT events. So let's welcome our second speaker for today, Mr. Saurabh Jain.
Good morning, everyone. I'm happy to share startup best practices with you. So, I believe that many of you must want to become an entrepreneur, and I think the other people who want to do job also would these days get a lot of jobs in startups. So, understanding startups is very important for career point of view. So I will introduce you to entrepreneurship, startups, and some of the best practices in startups. And also I will share some of the best practices which we can use in daily life related to startups. So who is an entrepreneur? An entrepreneur is somebody who can do more than what is thought possible for less than what thought possible. This definition was given by John Doerr. John Doerr is one of the legendary investors in America who invested in Google and Amazon more than 20 years ago. So you can just think how great an investor he is. So his definition is very simple. Entrepreneur is somebody who can do more than what is thought possible for less than what is thought possible. तो बेसिकली जो एक और एक 11 करता है वो एंटरप्रेन्योर है, जो एक और एक 2 करता है वो बिजनेसमैन है. what is a startup? A startup is any organization which builds a product or a service under uncertainty. This definition was given by author of Lean Startup book, a very famous writer called Eric Ries. He says that startup is any organization which builds a product or a service under uncertainty. So many people feel startup का मतलब होता है कि startup is a tech organization or startup is a small organization. तो जब मैं Paytm में I joined, so there is a lady who was in first 100 employees in Paytm. So she takes onboarding. तो she is in HR. तो she said क्या हम आज भी startup हैं? हमारे यहाँ तो अब 10,000 लोग हो गए हैं. जब when I joined, obviously we were a small organization and उस समय स्टार्टअप थी. तो मैंने उनको यही बताया, मैंने कहा स्टार्टअप तो है बिकॉज वी आर स्टिल बिल्डिंग प्रोडक्ट्स और सर्विस अंडर अनसर्टेनिटी. तो कुछ भी आप नया करोगे तो अनसर्टेनिटी होगी तो ऑब्वियसली स्टार्टअप कहलाएगी. तो टाइप्स ऑफ स्टार्टअप होते हैं. तो काफ़ी लोगों को ये क्लैरिटी नहीं होती स्टार्टअप किस टाइप के होते हैं. तो देखिए 4 टाइप्स के स्टार्टअप होते हैं. विनर टेक्स ऑल स्टार्टअप जैसे पेटीएम, उबर, ये वो स्टार्टअप है जो दुनिया को मुट्ठी में करना चाहते हैं. लाइफस्टाइल स्टार्टअप्स होते हैं. So there are smaller companies which act like startups, which are very fast, agile, building new things. तो बेस कैंप अमेरिका में एक बड़ी फेमस कंपनी है. वर्डप्रेस आपने सुना होगा. तो वर्डप्रेस की जो पीछे कंपनी है वो भी लाइफस्टाइल स्टार्टअप है. सो दे हैव गुड वर्क लाइफ बैलेंस. और ये बेस कैंप थी या जो वर्डप्रेस के पीछे जो कंपनी है, वर्डप्रेस सॉफ्टवेयर जो बनाती है, दे वर डूइंग रिमोट वर्किंग इवन बिफोर कोविड. तो उनको तो कोई फर्क ही नहीं पड़ा होगा कोविड से. सोशल स्टार्टअप, खान अकेडमी है. देर आर, सो दीज आर न्यू एज एनजीओज. पैसे नहीं कमाना चाहते, दे वांट टू डू सोशल इम्पैक्ट बट स्टार्टअप स्टाइल से चलते हैं. एंड कॉर्पोरेट स्टार्टअप, जियो, आई थिंक सबसे अच्छा एग्जांपल इस देश में जियो है. क्योंकि आप देखिए एयरटेल, वोडाफोन सब इतने एंट्रेंस थे. मुकेश अंबानी केम इन जियो एंड उन्होंने कर ली दुनिया मुट्ठी में. तो स्टार्टअप, कॉर्पोरेट स्टार्टअप को देखिए तो पूरा का पूरा कंपनी को उठा के स्टार्टअप बना दिया उन्होंने. गोल्स ऑफ अ स्टार्टअप पे आते हैं. देखिए गोल्स ऑफ अ स्टार्टअप और 3 गोल होते हैं. मैं जब आपकी उम्र में था तो आई हैड दिस गोल. आई वाज इन कॉलेज, आई हैड दिस गोल कि एक दिन मैं अपनी स्टार्टअप खोलूंगा, पोर्टफोलियो प्रोडक्ट्स होंगे, कल्चर आएगी, उसके अंदर ऐसी कल्चर होगी, बड़े बड़े लोग छोड़ के अपनी कंपनीज में जिसमें जॉब कर रहे हैं मेरी कंपनी ज्वाइन करेंगे. एंड आईपीओ आएगा, मैं करोड़पति अरबपति बन जाऊंगा. तो अब सपना तो ये था और आई थिंक काफी यंगस्टर्स का ये सपना रहता है आजकल. अनफॉर्चुनेटली ये सिखाता नहीं है कॉलेज. द गुड थिंग नाउ डेज आई एम सीइंग इज दैट कॉलेजेस आर डूइंग सच इवेंट्स. जैसे अभी हम आज वाला इवेंट है तो उसमें अभी जो पिछले स्पीकर थे मिस्टर परवेज, ही वाज स्पीकिंग अबाउट बेस्ट प्रैक्टिसेस इन टेकिंग पेटेंट्स एक्सेट्रा. सो अब मैं आपको स्टार्टअप्स की बेस्ट प्रैक्टिसेस बता दूं. आई थिंक ये अच्छे इनिशिएटिव्स हैं जो कॉलेजेस आर टेकिंग दीज डेज. हमारे ज़माने में थोड़ा कम होती थी ये चीज़ें. एंड आई थिंक जूम हैज़ ऑब्वियसली हेल्प दैट बिकॉज इट बिकम्स वेरी इजी नाउ टू डू सच इवेंट्स. सो जब मैंने अपना करियर शुरू किया तो मुझे पता नहीं था कि इन तीनों के लिए क्या करना है. मैंने काफ़ी सारे एक्सपेरिमेंट करे, काफ़ी सारी गलतियां भी करी. करते करते 2015 में आई रीच्ड अ स्टेज वेयर आई ऑर्डर्ड अ बुक फ्रॉम अमेजन. तो वो बुक के अंदर लिखा था दूसरी बुक पढ़ी है. मैंने दूसरी बुक पढ़ी. दूसरी बुक के साथ अमेजन पे जब जाते हैं तो वो और रिकमेंडेशन करके मैंने एक तीसरी बुक मंगाई, लीन स्टार्टअप. तो लीन स्टार्टअप पढ़ के काफ़ी क्लैरिटी हुई. उसके बाद मैंने 57 बुक्स पढ़ी पूरे साल में. माय मदर सेड अगर इतनी किताबें तो स्कूल में या कॉलेज में पढ़ लेता तो यूनिवर्सिटी टॉपर बन जाता. तो मैंने कहा उस समय मज़ा नहीं आता था पढ़ने में बिकॉज कॉलेज और स्कूल में उतना मज़ा नहीं आता पढ़ के. तो अब जब 10 साल थपेड़े सहे, 10 साल प्रॉब्लम सही, तो वो मेरे दिमाग में क्वेश्चंस पैदा होते गए. वो क्वेश्चंस ये बुक्स आंसर कर रही थी. तो आई रेड 57 बुक्स इन 2015. आई रेड 53 बुक्स इन 2016. तो 110 बुक के बाद क्या हुआ कि काफ़ी नॉलेज हो गई. आई स्टार्टेड गेटिंग लॉट ऑफ कंसल्टेंसी वर्क. एंड एक दिन मेरे को विजय शेखर शर्मा जो पेटीएम के फाउंडर हैं, ही वाज कॉलिंग मी फॉर 2-3 बार पहले भी बुला चुके थे. ही कॉल्ड मी अगेन. आई गेव हिम सम आइडियाज. बुक से बड़ा फायदा होता है, बड़े बड़े लोगों से बात करना आसान हो जाता है. सो ही लाइक माई आइडियाज. ही ऑफर्ड मी जॉब ऑफ वीपी एंड पेटीएम मैंने ज्वाइन की आफ्टर बीइंग अ एंटरप्रेन्योर फॉर 15 ईयर्स. तो जब पेटीएम में मैंने काम किया तो मैंने विजय को काफ़ी ऑब्जर्व किया. विजय को ही रिपोर्ट करता था मैं. तो प्रोडक्ट मैंने देखा विजय शेखर शर्मा 3 चीज़ों पे फोकस करते हैं. प्रोडक्ट, पीपल, परचेजिंग पावर. 3 चीज़ों पे फोकस है. मैंने बुक्स जो पढ़ी 200 किताबें पढ़ ली हैं अभी तक. वो दो मतलब पेटीएम जाने के बाद थोड़ी स्पीड तो कम हो गई बढ़ देंगे. 200 किताबें जो मैंने पढ़ी उनके अंदर भी यही निचोड़ निकला कि यू हैव टू फोकस ऑन प्रोडक्ट, पीपल, परचेजिंग पावर. फिर आते हैं स्टार्टअप लाइफ स्टेजेस पे। देखिए स्टार्टअप की 3 स्टेजेस होती हैं, सर्च, बिल्ड, स्केल। जनरली मीडिया वांट्स टू कवर स्केलिंग। एक बार जब मैं पेटीएम में नया नया गया तो मैंने विजय से पूछा, मैंने कहा पेटीएम काम तो बड़े अच्छे अच्छे करती है, ये फंडिंग की न्यूज़ ही क्यों आती है मार्केट में? तो इस साइड हम प्रेस रिलीज तो हर चीज़ का करते हैं, या ये अखबार वाले छापते हुए हैं जो ग्लैमरस होता है। तो स्केलिंग इज ग्लैमरस, आपको बड़ा अच्छा लगेगा, अरे इस कंपनी को इतने करोड़ मिल गए, ये यहाँ पर स्केल कर रही है, इसने ये किया, इसने इतनी ब्रांच खोली। बट वो जो एक्चुअल आइसबर्ग की तरह होता है कि 90% आइसबर्ग पानी के नीचे होता है, आपको सिर्फ 10% दिखाई दे रहा होता है। 90% मेहनत जो होती है वो स्केलिंग से पहले की होती है। तो आपको पहले सर्च करना है, फिर बिल्ड करना है। अब एक और क्वेश्चन आता है कि सर्च कब करना है? तो मेरे हिसाब से कॉलेज सबसे अच्छा टाइम है सर्च करने का। यू हैव एक्सेस टू मेंटर्स, यू हैव एक्सेस टू टीचर्स, यू हैव एक्सेस टू स्टूडेंट्स जो फ्रेंड्स हैं आपके। तो आप सर्च करिए, सर्च करके आपको समझ आएगा क्या बनाना है, पहले क्या बनाना है, फिर बनाओगे। ऑब्वियसली इंजीनियरिंग कर रहे हो तो बनाओगे, या अगर इंजीनियरिंग नहीं भी कर रहे तो यू कैन हैव अ को फाउंडर हु इज डूइंग इंजीनियरिंग और हु इज एन इंजीनियर। सर्च करिए, बिल्ड करिए और स्केल करिए। ये स्टेप्स रहते हैं स्टार्टअप के लाइफ स्टेजेस के। तो मैंने काफ़ी सारी ये जो बुक्स पढ़ के, विजय के साथ काम करके, सीनियर लोगों के साथ बातें करके, मैंने अपनी सारी किताबों का एक स्लाइड में अगर निचोड़ डालना है तो ये बनाया, स्टार्टअप कैनवस। तो बेसिकली 3 स्टेजेस, 3 प्रोडक्ट्स, 3 फोकस एरियाज, प्रोडक्ट, पीपल, परचेसिंग पावर, जिसको मैं 3 स्टेप्स टू स्टार्टअप सक्सेस कहता हूँ। तो ये 3x3 9 आपके सब स्टेप्स बन गए। तो प्रोडक्ट के 3 स्टेप्स हैं, प्रॉब्लम सॉल्यूशन फिट, प्रोडक्ट मार्केट फिट, ग्रोथ प्रॉफिट फिट। और ये पूरा का पूरा लाइफ साइकिल है एक स्टार्टअप का। अगर आपको ये 9 खाने समझ आ जाते हैं तो आप एक अच्छे सक्सेसफुल एंटरप्रेन्योर बन जाते हैं, विच इज़ वेरी इंपॉर्टेंट अगर आप आज के ज़माने में एक स्टार्टअप खोल के एंटरप्रेन्योर बनना चाहते हैं। एंड ये मैं आपको एक और चीज़ कहूँगा कि देखिए, करियर पॉइंट ऑफ व्यू से बता रहा हूँ। मैं जब कॉलेज में था 2001 में मैंने कॉलेज पास आउट किया, तो उस समय कोई भी फोन, कैमरा फोन नहीं था। मतलब अब मैं आपको थोड़ा कंटेक्स्ट दे रहा हूँ कि 20 साल में दुनिया कहाँ जाने वाली होगी। जब 20 साल पहले मैंने कॉलेज पार किया तो देयर वाज नो कैमरा फोन। जब मैं 10th में था तो मोबाइल फोन लॉन्च हुए थे। तो आप ये सोचिए कि 25 साल पहले मोबाइल फोन, 27-28 साल पहले मोबाइल फोन लॉन्च हुए इंडिया में। उसके बाद जब मैंने 20 साल पहले कॉलेज पार किया तो उस समय कैमरा फोन था ही नहीं। अगले साल कैमरा फोन लॉन्च हुआ। मोबाइल ऐप्स नहीं थी, मतलब आज उबर और पेटीएम और ये सारी चीजें हम यूज करते हैं, ऐप्स भी नहीं थी मोबाइल ऐप्स, सोचिए। तो जो आप आज पढ़ रहे हैं वो 20 साल बाद रेलिवेंट नहीं होगा। अब 20 साल आपको सोचने में ज्यादा लगेंगे, बट 20 साल कोई ऐसे खास नहीं होते। मैं जब 20 साल का था और उसके बाद 40 साल का ही हुआ, उसमें कोई बहुत ज्यादा डिफरेंस नहीं है एज के अंदर। मैं उस एंगल से कह रहा हूँ, कोई मतलब जनरल लाइफ टाइम तो हमारी 60 साल 70 साल तो एटलीस्ट होती है होपफुली। कोविड ने ऑल्दो काफी यंग लोगों को भी लिया है। तो मैं आपको ये कह रहा हूँ कि प्लान योर करियर फॉर लॉन्ग टर्म। डोंट प्लान कि अरे अगले 2 साल में क्या चल रहा है ये कर लेता हूँ। जैसे एक एग्जांपल है, मेनी यंगस्टर्स फोकस ऑन जावा। अब जावा एक मरती हुई लैंग्वेज है। अब आप जावा पे फोकस करेंगे तो करियर कुछ बनेगा नहीं। मतलब आज तो बन जाएगा बट वो लॉन्ग टर्म इज नॉट जावा। आज एंड्रॉयड में कॉटलिन आ गई है, iOS के अंदर जो पहले ऑब्जेक्टिव सी थी उसकी जगह आजकल स्विफ्ट आ गई है। तो व्हाट आई एम सेइंग इज AI विल टेक ओवर जॉब्स इन नेक्स्ट 20 इयर्स। रिमोट वर्क होना ही लगी गया है अब। तो अभी मैंने अपनी कंपनी के अंदर सारे एम्प्लॉयज रिमोट कर दिए हैं। बड़ा फायदा हुआ, जब सेकेंड वेव आई तो हमारा काम इम्पैक्ट नहीं हुआ। वी वर गोइंग एट फुल स्टीम बिकॉज अगर हम फिजिकल काम कर रहे होते तो प्रॉब्लम आती। पेटीएम इतनी बड़ी कंपनी है, अभी तक रिमोट वर्क ही चल रहा था। दे हैव नॉट स्टार्टेड फिजिकल ऑफिस। इवन फरवरी में भी नहीं स्टार्ट किया था फिजिकल ऑफिस। तो व्हाट आई एम सेइंग, try to understand startup best practices because future is in not in jobs, future is in creating your own startup or working in a startup because वो जो existing companies हैं उनका काफी सारा काम AI ले लेगी और काफी सारे जो existing jobs हैं जो हम physical world में करते हैं वो सारे remote working और online जो systems हैं, automation है वो ले लेगी। सो कमिंग टू दिस, तो इसमें देखिए प्रॉब्लम सॉल्यूशन फिट का मतलब है कि आप सबसे पहले प्रॉब्लम सोचिए मैंने क्या करना है। तो स्टार्टअप इज द बेस्ट टूल फॉर सॉल्विंग प्रॉब्लम्स ऑफ द कंट्री। स्टार्टअप शुरू होती है एक प्रॉब्लम से, फिर वो एक सॉल्यूशन सोचती है कि ये प्रॉब्लम ऐसे सॉल्व होगी। तो जैसे पेटीएम एक प्रॉब्लम के साथ शुरू हुई कि लोग ऑनलाइन पेमेंट्स कैसे कर सकते हैं। सॉल्यूशन सोचा है कि लोग मोबाइल ऐप से ऑनलाइन पेमेंट कर सकते हैं। प्रोडक्ट बनाया उन्होंने, एक मोबाइल ऐप बनाई जिससे ऑनलाइन पेमेंट हो सकती है। उसमें इनिशियली उन्होंने रिचार्जेस से स्टार्ट किया, फिर वो मार्केट में गए, मार्केट में प्रोडक्ट अच्छा चला, एक दिन डिमोनेटाइजेशन हुई तो और ज्यादा अच्छा चला। अब जब डिमोनेटाइजेशन हुई तो दे स्टार्टेड ग्रोइंग, क्योंकि ग्रोथ पे जब तक कंपनी ने इन्वेस्टमेंट भी ले ली थी, ग्रोथ शुरू हो गई और फाइनली आज कंपनी प्रॉफिटेबल होने की ट्रैक पे है और प्रॉफिटेबल होती जा रही है, बिकॉज इकोनॉमीज ऑफ स्केल चाहिए होते हैं, पहले दिन आप प्रॉफिटेबल नहीं होते। देन वी कम टू पीपल। सबसे पहले आपको को फाउंडर ढूंढने पड़ते हैं, फिर आप एक को टीम ढूंढते हो और फिर आप कॉर्पोरेशन बनाते हो। दिस इज द स्टेप। आप कहीं भी देखिए यही होता है। आपने कभी गुरु फिल्म देखी हो तो उसके अंदर देखा होगा वो अभिषेक बच्चन धीरू भाई का कैरेक्टर कर रहे हैं, तो उसमें वो फाउंडर पहले जोड़ते हैं, उसके बाद फिर वो कुछ लोग जोड़ते हैं अपने साथ, को टीम बनाते हैं और फिर बाद में वो कॉर्पोरेशन बनती है। परचेजिंग पावर देखिए, सबसे पहले यू आर अ स्टूडेंट, नोबडी वुड फंड यू, तो आपको बूटस्ट्रैपिंग करनी है। सपना बहुत हाई होगा बट ऑब्वियसली आपको अपने पैसे 1 लाख 2 लाख लगाने पड़ेंगे। अच्छी चीज ये हो गई है कि नाउ गवर्नमेंट अंडर स्टार्टअप इंडिया एंड वेरियस इंक्यूबेटर्स आर देयर, तो इंक्यूबेटर्स में जा सकते हैं। 5 लाख से 15 लाख तक कई बार इंक्यूबेटर्स दे देते हैं। दूसरा ये है कि देर आर एंजल इन्वेस्टर्स। अगर आपका प्रोडक्ट आप थोड़ा सा 1-2 लाख लगा के प्रोडक्ट वाली स्टेज पे ले आते हैं, मिनिमम वायबल प्रोडक्ट, जुगाड़ प्रोडक्ट भी बना लेते हैं, तो आप एंजल इन्वेस्टर के पास जा सकते हैं। यू कैन टेल सर मैंने ये बनाया है। एंजल इन्वेस्टर्स जनरली वांट टू फंड इवन स्टूडेंट्स, तो 5 लाख से 1 करोड़ के बीच में लगाते हैं एंजल इन्वेस्टर्स। आप एंजल इन्वेस्टर के पास जाएंगे, वो पैसे दे सकते हैं आपको। एंड फाइनली आप जब प्रोडक्ट मार्केट फिट हो जाता है, प्रोडक्ट मार्केट में हिट हो जाता है, तो आपको वेंचर कैपिटलिस्ट पैसे देना शुरू कर देते हैं। वेंचर कैपिटलिस्ट तो मिनिमम 1-1.5 करोड़ देते हैं और स्काई इज द लिमिट। पेटीएम जैसी कंपनी ने हजारों करोड़ उठा रखे हैं मार्केट से, वेंचर कैपिटलिस्ट से। तो एक फाइनली आता है मैं कब स्टार्टअप खोलूं। तो देखिए, स्टार्टअप खोलने से पहले आपको एक एक ऐसा आइडिया चाहिए जो खजाने की तरह हो, कि एक पहाड़ पे रखा है। इट्स नॉट अ वेरी सिंपल आइडिया कि मतलब एक तो होता है कि एक बड़ा नो ब्रेनर आइडिया होता है, पहले हजारों लोग उसमें कूद चुके होते हैं, वो वाला आइडिया भी नहीं चाहिए। बट ऐसा आइडिया भी नहीं चाहिए कि जिसपे आप पहाड़ पे पहुंच ही ना सको। तो आपको ऐसा आइडिया होना चाहिए विच इज हैविंग अ सम मतलब विच इज यूनिक इन दैट सेंस कि अगर ये चीज होगी तो सारी दुनिया इसके लिए आपको पैसे देगी। बट वो थोड़ा पहाड़ पे भी होना चाहिए। इट शुड नॉट बी वेरी इजी टू रीच, बिकॉज अगर कोई भी उस प्रोडक्ट को कॉपी कर सकता है आपसे तो फिर तो कंपटीशन आ जाएगा। तो आपको आप फेसबुक को देखिए, फेसबुक से पहले सोशल नेटवर्क थे बट वो उतने अच्छे नहीं थे। तो मार्क जकरबर्ग ने एक आइडिया सोचा कि एक ऐसा फेसबुक, एक ऐसा नेटवर्क बनाता हूँ जिसमें फीड होगी। उससे पहले फीड ज्यादा कॉमन नहीं थी सोशल नेटवर्क पे, तो उन्होंने वो आइडिया सोचा। अब आपने देखा कि वो पहाड़ पे खजाना रखा था, मार्क जकरबर्ग पहले आदमी थे, उस खजाने पे चढ़ गए और आज वो $100 बिलियन की कंपनी चला रहे हैं। अभी लास्ट मैंने फेसबुक देखी थी 1 हफ्ते पहले, उसकी मार्केट कैप थी $800 बिलियन। $800 बिलियन पता है कितने होते हैं आपको? 56 लाख करोड़। मतलब हम करोड़पति होने से ही खुश हो जाते हैं। 56 लाख करोड़ की वैल्यूएशन है फेसबुक की। तो उन्होंने एक सपना देखा कि मैं अगर ये करूंगा तो एक खजाना मुझे मिलेगा, और वो खजाना पहाड़ पे था। मतलब वो ऐसा नहीं था कि गूगल ने कितनी कोशिश करी, गूगल जिसके अंदर भरे पड़े हैं IIT स्टैनफोर्ड वाले लोग, उन्होंने कितनी कोशिश करी फेसबुक को हराने की, बट दे कुड नॉट कैच जो फेसबुक का खजाना था उसको। वो खुद नहीं पकड़ पाए गूगल वाले। आज भी सोशल नेटवर्क में गूगल 0 है। तो वो रीजन क्या हुआ कि रीजन जकरबर्ग ने जो खजाना सोचा दिमाग में, वो पहाड़ पे था। वो मतलब इट वाज नॉट इजीली एक्सेसिबल। तो जकरबर्ग के पास एक कंपेटिटिव एडवांटेज थी। तो आपको कुछ भी ऐसा सोचना है जिसके अंदर आइडिया अच्छा हो, लोग उसके पैसे देने को तैयार हो और कंपेटिटिव एडवांटेज भी हो। इट शुड नॉट बी कि कोई भी कॉपी कर सकता है, कोई टॉम डिक हैरी आया और आपकी कॉपी कर देगा। तो व्हेन शुड आई स्टार्ट दी स्टार्टअप? देखिए, मेरे को तो सबसे बेटर टाइम लगता है इंडिया के सर्कमस्टांसिस के हिसाब से, कॉलेज इज द बेस्ट टाइम टू स्टार्ट दी स्टार्टअप। क्योंकि हमारे यहाँ एक और कल्चर प्रॉब्लम ये है कि हमारे यहाँ पेरेंट्स जैसे ही आप पास करोगे कॉलेज, कहेंगे जॉब करो। एंड हर आदमी कहेगा कि अगर तू जॉब नहीं कर रहा तो तू नुकसान कर रहा है, देख तेरा पड़ोसी का अंकल का लड़का इतना कमा रहा है। तो एक लड़के की कहानी सुनाता हूँ मैं आपको। सो ही मेट मी इन एन इवेंट। थोड़े दिन बाद ही टोल्ड मी ही इज रनिंग अ स्टार्टअप। थोड़े दिन के बाद मैं मिला, ही सेड मैं मास्टर्स कर रहा हूँ। तो मैंने कहा तू तो स्टार्टअप खोल रखी थी? तो ही सेड हाँ सर, वो स्टार्टअप थोड़ी चल नहीं रही थी। तो एक दिन मामा जी और चाचा जी आ गए एंड दे सेड पापा से कि ये लड़का टाइम वेस्ट कर रहा है, इसको क्या हो जॉब करे। एंड ही सेड सर प्रेशर इतना हो गया कि मैंने कहा पापा ऐसा जॉब तो नहीं करनी, अभी मास्टर्स करा दो। तो फादर वाज हैप्पी स्पेंडिंग मनी ऑन मास्टर्स। तो बोला सर 2 साल मिल गए मेरे को मास्टर्स में अपनी स्टार्टअप के लिए। तो आई थिंक बेस्ट टाइम इज कॉलेज, बिकॉज कॉलेज में पेरेंट्स का प्रेशर नहीं होता, कॉलेज में आजकल स्टार्टअप्स पे फोकस होने लग गया है, तो कॉलेज मैनेजमेंट का थोड़ा सपोर्ट हो जाता है कई जगहों पे। इंक्यूबेटर्स आ गए हैं, तो कॉलेज में इंक्यूबेटर्स वगैरह एक्सप्लोर करने इसलिए भी इजी हो जाते हैं। मेनी कॉलेजेस हैव इंक्यूबेटर्स एंड मेनी कॉलेजेस आर इन एजुकेशनल एरियाज जहाँ पर इंक्यूबेटर्स होते हैं, जैसे समझ लीजिए पुणे है, मुंबई है, दिल्ली है। यहाँ पर अगर आपके कॉलेज में भी इंक्यूबेटर नहीं है तो एटलीस्ट देर आर लॉट ऑफ इंक्यूबेटर्स इन सर्टेन एरियाज। जबकि अगर आप कॉलेज में नहीं है तो अगर आप शहरों में नहीं रहते तो जनरली इंक्यूबेटर एक्सेस नहीं होगी, बट जनरली एजुकेशनल एरियाज में एक आध इंक्यूबेटर जरूर होता है। इनफैक्ट इवन IITs अलाउ यू टू, अगर आप जैसे आपका कॉलेज से अगर आप जाते हैं, आप IIT बॉम्बे के इंक्यूबेटर में अप्लाई करते हैं, इवन दे अलाउ सच पीपल। मतलब ऑब्वियसली एंड आई वुड सर्टेनली से IIT जी से ज़्यादा आसान होता है, बिकॉज मतलब 100 कंपनी अप्लाई करेंगी तो एक को अलाउ कर देते हैं। वो IIT जी की तरह नहीं होता कि 3 लाख अप्लाई करेंगे और 3000 पास होते हैं। तो वो थोड़ा सा इजी हो जाता है आपके केस में, 100 से ही कंपटीशन होता है। एंड देन फाइनली देखिए, जब भी कंपनी खोली, अगर आप इंजीनियर भी हैं, मेरे को अभी इस समय ऑडियंस का आइडिया नहीं है कि कितने लोग इंजीनियरिंग कर रहे हैं और कितने और स्ट्रीम्स के हैं, बट एक चीज़ बड़ी क्लियर है कि अगर आपको फाउंडर बनना है तो आपको थोड़ा CFO बनना पड़ेगा। वो आई फॉर्चुनेटली डिड CA। मेरी मदर हमेशा कहती थी कि मेरे फादर की डेथ हो गई थी IIT, शी सेड कि अगर IIT जाएगा तो दिल्ली से बाहर जाना पड़ेगा, और फादर की डेथ हो गई तो शी डिडंट वांट टू सेंड मी आउटसाइड दिल्ली, बट शी ऑलवेज यूज्ड टू से कि एक डिग्री जरूर लेनी चाहिए, और CA की डिग्री बड़ी इंपॉर्टेंट रहेगी जब तू बिजनेस करेगा। बिकॉज आई ऑलवेज वांटेड टू स्टार्ट अ स्टार्टअप। आई वुड नॉट से कि सब CA करें या MBA करें। व्हाट आई वुड से इज कि आपको एक वो एटीट्यूड होना चाहिए। जैसे विजय शेखर शर्मा जो पेटीएम के फाउंडर हैं, सो ही इज नॉट अ CA और MBA, बट उनकी जो बिजनेस सेंस है, आई वुड से दैट इज बेटर देन मोस्ट CAs एंड MBA। तो आपको थोड़ा समझ आना चाहिए कंपनी फॉर्मेशन कैसे होती है। अच्छा CA और लॉयर ढूंढिए जो आपको इनकम टैक्स, अकाउंट्स, ऑडिट में हेल्प कर सकता है। TDS होता है ट्रांजैक्शंस पे, आपको GST और TDS काटना होता है, GST कलेक्ट करना होता है। पेरोल होता है, आपको एम्प्लॉयज़ को सैलरी स्लिप वगैरह देनी होती है, उसकी प्रोसेसिंग। तो वो अच्छा CA अगर आप ढूंढेंगे और लीगल के लिए अच्छा लॉयर ढूंढेंगे, आई थिंक एग्रीमेंट्स करने बड़ा इंपॉर्टेंट होते हैं। तो वो थोड़ा सा फ्रेमवर्क ऑफ माइंड लाइए। जैसे मिस्टर परवेज भी अभी कह रहे थे कि जब आप IP लेते हैं तो केसेस वगैरह आ सकते हैं, देयर आर लीगल इशूज। तो आई थिंक वो सारे पे थोड़ा दिमाग लगाइए, बिकॉज स्टार्टअप फाउंडर और एक प्योर इंजीनियर में थोड़ा सा ये फर्क होता है कि प्योर इंजीनियर सिर्फ बनाना जानता है। तो अगर मैं आपको थोड़ा अध्यात्म के एंड से लेके जाऊं तो प्योर इंजीनियर ब्रह्मा जी वाला काम करता है, वो सिर्फ क्रिएटर होता है। बट जो स्टार्टअप फाउंडर होता है वो विष्णु जी वाले काम भी करता है, और वो कई बार शिव जी वाले काम भी करता है। तो आप ये देखिए, वो बनाता तो है ही स्टार्टअप फाउंडर, पर आज जैसे आपने देखा वो जो कंपनी ने दूसरी कंपनी के पेटेंट्स पे केस किया, और शिव जी वाला काम है कि दूसरे को आप कह रहे हो कि ये चीज़ तूने गलत किया, आप उसको सजा दे रहे हो। और ऑब्वियसली आपको कंपनी रन करनी है, यू हैव टू डू ऑल दीज अकाउंट्स एंड ऑल दीज थिंग्स। थोड़ा वो एटीट्यूड लेके आइए। तो विद दैट मैं एक चीज़ और शेयर करना चाहूँगा। आई थिंक एज अ स्टूडेंट्स आप लोगों के लिए बड़ा इंपॉर्टेंट है। काफ़ी लोगों को क्वेश्चन होता है, सर क्या करें लाइफ में, तो विच प्रॉब्लम टू फोकस ऑन। तो देखिए, एक तो ये है कि हमारी देश में किस्मत अच्छी है कि हम ऐसे देश में पैदा हुए हैं जहाँ इतनी सारी प्रॉब्लम्स हैं, तो एटलीस्ट प्रॉब्लम ढूंढने की प्रॉब्लम तो नहीं है। तो वी आर ब्लेस्ड कि वी आर बॉर्न इन अ कंट्री जहाँ पर प्रॉब्लम ढूंढने की प्रॉब्लम नहीं है। दूसरा, क्या प्रॉब्लम ढूंढूं, तो देखिए एलोन मस्क को देखिए, एलोन मस्क क्या कर रहे हैं, उसका फॉर्मूला मैं आपको बताता हूँ। डू व्हाट यू लव, डू व्हाट यू आर गुड एट, डू व्हाट यू कैन बी पेड फॉर एंड व्हाट द वर्ल्ड नीड्स। एलोन मस्क क्या कर रहे हैं, उनको ये पसंद है काम जो कर रहे हैं, टेस्ला बना रहे हैं, स्पेसएक्स बना रहे हैं। ही इज ऑब्वियसली गुड एट इट, उनका दोनों में नाम है। ही इज बीइंग पेड फॉर इट। दुनिया के 3rd रिचेस्ट हो गए हैं, अभी बीच में 1st हो गए थे रिचेस्ट, तो ऑब्वियसली पेड तो हो ही रहे हैं। एंड दुनिया को चाहिए एक इलेक्ट्रिक कार। आज मिडिल ईस्ट में रोज सुबह शाम कुछ ना कुछ टेंशन होती रहती है। आपने देखा होगा अभी इजराइल के साथ कुछ इशू हो रहा है। तो आप ये देखिए, मिडिल ईस्ट से ऑयल पे डिपेंडेंस थी दुनिया को, एलोन मस्क आए, उन्होंने टेस्ला बनाई, ऑब्वियसली वर्ल्ड नीडेड दैट। तो एज एन एंटरप्रेन्योर आप देखिए, चाहे विजय शेखर शर्मा को देखिए, ही इज डूइंग व्हाट ही लव, ही इज गुड एट इट, ही इज अ बिलियनियर, ऑब्वियसली इज गेटिंग पेड फॉर इट। व्हाट दी वर्ल्ड नीड्स, सबको पेटीएम चाहिए या पेटीएम जैसी पेमेंट सोल्यूशन चाहिए। तो मैं यही कह रहा हूँ कि आपको एज अ इंजीनियर डोंट ट्राई टू डू कि यार मेरे मामा का लड़का ये कर रहा है, वो सिलिकॉन वैली में चला गया, उसकी इतनी तनख्वाह है। उसकी जगह फोकस करिए कि ये 4 चीज आपको मिल जाती हैं तो आपकी इकिगाई मिल जाती है आपको। ये इकिगाई एक बड़ी फेमस बुक है, मैंने पढ़ी, मेरे को बड़ी अच्छी लगी। एंड बेसिकली है पैशन, मिशन, प्रोफेशन, वोकेशन। जिस दिन मिल जाएगा उस दिन आपको दुनिया में कोई नहीं हरा पाएगा। कई बार हार्ड डिसीजंस लेने पड़ते हैं। आई वॉज इन पेटीएम, आई रियलाइज आई वॉज गेटिंग पेड फॉर इट, दुनिया के लिए कुछ अच्छा ही कर रहे थे. आई वॉज रिलेटिवली ओके इन इट, बट वॉट आई रियलाइज वॉज मेरे को वो आई वॉज नॉट लविंग माई जॉब. तो इसलिए मैंने पेटीएम छोड़ी. मैंने कहा क्योंकि अगर मेरे को ये, मैं जो लोगों को बोलता हूँ कि आप अपनी इकीगाई ढूंढिए, तो मेरी इकीगाई तो पेटीएम में नहीं है. तो मैंने अपनी इकीगाई ढूंढी और फिर मैंने जॉब छोड़ के अब अपनी स्टार्टअप लॉन्च की है, फन टू डू लैब्स, बिकॉज आई वांटेड टू सॉल्व द एजुकेशन प्रॉब्लम. मेरे को लगता है कि दुनिया में एजुकेशन प्रॉब्लम सॉल्व करने के लिए मुझे अपना जीवन स्पेंड करना चाहिए. अगर मैं वो सॉल्व कर दूंगा तो माई स्टार्टअप वुड गेट सक्सेसफुल. नहीं भी कर पाऊंगा तो एटलीस्ट आई वुड बी सेटिस्फाइड कि मैंने ये प्रॉब्लम सॉल्व करने की कोशिश करी. दूसरा, एवरी ग्रेट सॉल्यूशन शुड बी डिजायरेबल, फिजिबल, वाइबल. हमारे देश में अनफॉर्चुनेट ट्रेजेडी ये है, हम बहुत ज्यादा कोडिंग इंजीनियरिंग पे बड़ा फोकस करते हैं, बट हम ये नहीं सिखाते किसी भी इंजीनियर को कि डिजाइन कैसे करते हैं. सिलिकॉन वैली में खास चीज ये है कि इंजीनियर्स डिजाइन सीखते हैं. एप्पल के जो फाउंडर थे स्टीव जॉब्स, उन्होंने डिजाइन सीखा, इस वजह से एप्पल के कंप्यूटर डिजाइन में अच्छे हुए. तो वी हैव टू लर्न डिजाइन, वाइबल. एमबीए में सिखाते हैं आजकल, काफी इंजीनियर्स एमबीए करते भी हैं. तो आपको वाइबिलिटी करनी है कि कमर्शियली वाइबल हो आपका प्रोजेक्ट. तो डिजायरेबिलिटी, वाइबिलिटी, फिजिबिलिटी, ये 3 चीजें जरूर सीखिए. तो विद दैट आई वुड लाइक टू ओपन फॉर Q&A बिकॉज हमारे पास थोड़ा सा ही टाइम बचा है. So I would be happy to answer questions related to startups or any other topic related to business.
Sir, can we start a business when we are still employed?
हाँ देखिए, when you are employed you can start a business, when you are in a college you can start a business. Employed में बस थोड़ा सा आपको ये ध्यान रखना पड़ेगा कि many companies have policy, active policies कि आप कुछ और काम नहीं कर सकते, तो आपको परमिशन लेनी पड़ेगी. जैसे मैं पेटीएम में जब गया तो सबसे पहले तो जब विजय ने मुझे कहा कि आप ज्वाइन करो, तो मैंने उनके सामने एक ही कंडीशन रखी. मैंने कहा मेरी एक स्टार्टअप है. अब वो ठीक है, मैं यहाँ ज्वाइन करना चाहता हूँ तो मैं ज़्यादा चलाऊंगा नहीं, बट मैं स्टार्टअप लीगली चलाते रहना चाहता हूँ. मेरे जो भी एम्प्लॉयज रहना चाहते हैं स्टार्टअप में, मैं उनको भी रखना चाहता हूँ. तो विजय बोले ठीक है कर लो, कोई प्रॉब्लम नहीं है. एंड आई बेसिकली टोल्ड दी कंपनी कि मैं ये कंपनी चलाता रहूँगा. तो ही दे से ठीक है चला लो. तो एक तो वो होता है, कई बार ये भी होता है बिकॉज यू आर एट, मतलब मैं तो थोड़ा सीनियर पोजीशन पे गया था तो थोड़ा सा आई कुड नेगोशिएट इट. जूनियर लेवल पे वो चीज़ नहीं भी होती. तो व्हाट यू कैन सी इज कि आपके जो लीगल एग्रीमेंट्स हैं, आर दे स्टॉपिंग इट. बिकॉज कई बार ये होता है कि आपने कंपनी में रहते हुए जो भी इन्वेंशन करी, वो इन्वेंशन दूसरी कंपनी की हो, मतलब जिसमें आप एम्प्लॉयड हैं उसकी हो जाती है. तो वो भी एक रीज़न हो जाता है. तो वो आपको थोड़ा देखना पड़ेगा कि जो आप इन्वेंट कर रहे हो वो उस कंपनी का पार्ट होगा या नहीं होगा, आपके एग्रीमेंट में क्या है. बट जनरली आई वुड से अगर आपको एक छोटी स्टार्टअप खोलनी है, यू कैन ऑलवेज स्टार्ट अ स्टार्टअप. एंड जनरली जब तक आपने कुछ बहुत ही वर्ल्ड चेंजिंग नहीं किया, आपकी एम्प्लॉयर आपके ऊपर केस नहीं करेगी. बिकॉज आपने छोटा मोटा कोई ऐप बना ली और वो बाद में लॉन्च की 2 महीने के बाद, तो वो एम्प्लॉयर इज नॉट दैट इंटरेस्टेड, उसको कोई फर्क नहीं पड़ रहा. एंड दे जनरली डोंट डू केस. We can have next question. Hello, we can have the next question. Hello.
Yeah, I think Siddhika, they're not having any questions further. Siddhika?
Yes, ma'am. Yes, ma'am.
So you can follow me at Twitter on @skjsaurabh. आप मुझे फॉलो कर सकते हैं. आई राइट ब्लॉग ऑन स्टार्टअप्स. तो मेरी ब्लॉग, ये जो मैंने आपको अभी स्लाइड्स भी शेयर करें, ये startuplearn.org पे है. मैं आपको लिंक दे देता हूँ. एंड आई एम क्रिएटिंग दिस ब्लॉग बिकॉज देखिए, मैं 2 मिनट ये लेके आई वुड लाइक टू एंड. तो मैं बेसिकली अगर आपको बताऊं तो द रीजन वाई आई एम फोकसिंग ऑन क्रिएटिंग startuplearn.org, क्योंकि जब मैंने स्टार्टअप लॉन्च करी 2003 में, आई वॉज स्ट्रेट आउट ऑफ कॉलेज. आई वॉज डूइंग CA एट दैट टाइम. तो मैंने ये रियलाइज किया कि कोई भी स्टार्टअप सिखाता नहीं. एंड मतलब इट टुक हार्ड 10 हार्ड ईयर्स टू लर्न बिजनेस प्रैक्टिकली. उसके बाद जो बुक्स पढ़ी, विजय के साथ काम किया, तो काफ़ी चीज़ें लर्न करी. तो आई वॉन्ट टू शेयर माई नॉलेज. एंड आई वुड सर्टेनली से कि देखिए, वो जो पुराना ज़माना था ना कि आपने जॉब करी, आप एक MNC में चले गए, आपको लग रहा है मैं अमेरिका चला जाऊँ, वो पुराना ज़माना था. आई थिंक रिमोट वर्किंग का ज़माना आ गया है. एक तो आई थिंक आगे आगे अमेरिकन जॉब्स ही इंडियंस के लिए कम हो जाएंगे, बिकॉज रिमोट वर्किंग होगी तो मतलब आपको सिलिकॉन वैली में फिजिकली तो प्रेजेंट होने की ज़रूरत ही नहीं पड़ेगी. तो मोस्ट कंपनीज वुड नॉट send you abroad. दूसरा ये है कि जो IT कंपनीज का वैसे भी चलन था, आई थिंक वो धीरे धीरे AI के थ्रू lot of jobs will be lost in IT because जैसे जैसे things would be automated, वो फर्क पड़ेगा. कोडिंग वोडिंग भी काफी हद तक कई चीजें ऑटोमेट होंगी. तो व्हाट आई एम सेइंग इज कि आपको अपना करियर करने के लिए आपको ये चीजें समझनी पड़ेंगी. दूसरा देखिए, कॉलेज के अलावा भी यू वुड हैव टू लर्न लॉट ऑफ थिंग्स. तो वो मैं आपको एक शेयर कर रहा हूँ, जो मैंने 200 किताबें पढ़ी हैं. आप वो 200 किताबों में से जो मैंने अंडरलाइन कर रखी हैं, कुछ किताबें मैंने अमेजन के लिंक कर रखे हैं, वो सबसे इंपॉर्टेंट किताबें हैं. और बाकी और भी जो भी आपको लगे वो जरूर पढ़िए. बिकॉज करियर बनाने के लिए अगर आप सोचोगे कि सिर्फ कॉलेज की पढ़ाई से हो जाएगा, कॉलेज की पढ़ाई मतलब अगर मैं एनालॉजी दूं खाने की, तो कॉलेज की पढ़ाई रोटी की तरह है. तो रोटी ठीक है इज इम्पोर्टेंट, बट एट द एंड ऑफ द डे इफ यू वांट, जैसे अगर आप जिम जाते हो तो प्रोटीन पाउडर खाते हो, तो इस तरीके से आपको प्रोटीन शेक पीते हो, तो इस तरीके से वो जो प्रोटीन शेक है रियल लाइफ में, दोज आर बुक्स. और वो बुक्स अगर आप नहीं पढ़ोगे तो काम नहीं चलता. तो ये 200 बुक्स की लिस्ट मैंने भेजी है आपको लिंक पे, एंड यू कैन ऑलवेज फॉलो मी ऑन सोशल मीडिया, ऑन लिंक्डइन एंड ट्विटर एट SKJ सौरभ. और अगर आप आई शेयर बेस्ट प्रैक्टिसेस एक्सेट्रा, एंड आई वुड सर्टेनली से दैट आप इनोवेशन की तरफ सोचिए. हमारे देश को इनोवेशन की जरूरत है. आपने देखा ही अभी कोविड में लास्ट 1-2 महीने में हमारा कितनी दुर्गति हुई है देश की. तो आई वुड से, एंड आई थिंक यू आर इन मुंबई, एंड मुंबई के अंदर तो आपने देखा ही सबसे पहले प्रॉब्लम वहीं शुरू हुई थी. तो आप ये देखिए कि ये इनोवेशन चाहिए हमें आज ये सॉल्व करने के लिए. इंडिया में जो RT-PCR या जो और अभी होम टेस्टिंग किट्स वगैरह बन रही है, ये इंडियन एंटरप्रेन्योर्स बना रहे हैं. या जो नई वैक्सीन्स बन रही हैं इंडिया में, काफ़ी एंटरप्रेन्योर्स बना रहे हैं. तो व्हाट आई वुड से इज कि बिल्ड फॉर इंडिया बिकॉज योर कंट्री नीड्स यू.
Yes, Siddhika.
Yes, ma'am. Gauri?
Yes. Sir, your journey is truly inspiring and listening about it was marvelous. I'm sincerely grateful for your part in our workshop. Thank you so much, sir, for being such a wonderful speaker.
Welcome.
Thank you so much, sir. Students, you can fill the feedback form so that later we can share your certificates on your email ID. Now I would like to call Nirmal Dubey to propose the vote of thanks.
Uh, Good afternoon, everyone. Firstly, let us thank Almighty for blessing us to get us through this unprecedented catastrophe. Coming to our event, firstly, I would like to thank Dr. Usha Mukundan ma'am and Dr. Himanshu Davda sir for giving us the permission to conduct such an event amidst a pandemic, and to avail us with required prerequisites to curve out wonderful workshop on entrepreneurship and intellectual property right. Secondly, a very big thank you to our resource person, namely Mr. Parvez Kuroli, sir, Mr. Saurabh Jain, sir, for being such a good speakers for today and driving the trajectory of the event to the next level. Your presence was of utmost importance today, sir. And also thank you for the wise words, your experience, knowledge, career development tips for sharing at this forum. And moving ahead are the audience who are the real foundation stones at the today's show. Each and every one of you guys of top notch. It was you guys who made this event workshop a grand success. Moving forward, the management team, right from our below Selvi ma'am, every single person involved in the making of this event a grand success. A big thank you to everyone. Lastly, the team technicals who did the fantastic job in getting acquainted with the demands of the situation and fulfilling each of them diligently. Thank you, everyone. This is Nirmal Dubey, student in charge, RGIIC, signing out. Thank you.
Thank you, Parvez sir, and thank you, Saurabh Jain sir. I think we'll end the week now.
Okay, ma'am.
Yes, ma'am. I'll end the meeting for all.
I think we'll wait if I hope people have signed the attendance.
Yes, ma'am.
We'll wait for another 5 minutes. Let people to sign the attendance. I think people are giving the attendance and they're leaving themselves. Nawaz Khan, the link has been sent. Oh, dekho upar. I think we can end ना now. कर दिया रहेगा ना?
Yes, ma'am.
2 मिनट रुकते हैं ना मैम.
हाँ ठीक है क्योंकि और भी बच्चे पूछ रहे रुकते. तो मैं
हाँ.
लीव करती हूँ ना, तुम अटेंडेंस देके फिर वर्क देख लो. मैं लीव
हाँ
करती
चलेगा
हूँ.
ना. It is the same. Okay, BSc student also. Yeah, you all will get e-certificates on your mail address. Then shall we close this Zoom now?
Yes, ma'am.
Feedback form you have to fill up. Then only you will receive the e-certificate on your mail. All of you have to fill the feedback form.
Yes, ma'am. Already.
ओके, चलो बाय बाय। सिद्धिका क्लोज कर दो लिंक।
हाँ मैम, हाँ मैम।